Megan Fox.
And Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox writes at PJ Media.
Eat Tucker.
And that was your last.
Damn it, man. I cried for 2 days.
Megan, thank you very much for that.
So, I can explain the bed thing.
If you don't show up and vote, up your ass. I don't care if you're in the hospital. Crawl to the stake. Crawl there.
It's like Jesus going into the temple. He's like, I got a whip. Get out! Get out!
The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood and has toe thumbs.
Megan Fox.
Megan. And honestly, Megan, if you don't like it, I'm sorry.
She's the devil.
Megan Fox. Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go? Holy sh!
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's
You pissed off the wrong woman.
oh my God, I have been assaulted, but Megan Fox runs wild on you, brother.
She's the devil. Not for publication.
The story.
I'm Megan.
Megan.
Megan Fox.
Thank
Thank you. Cheers.
Hey guys, good evening. I'm back. I promised I would be. So we were catching up on the Maya Kowalski trial. Yes, I'm the Megan Fox without the toe thumbs, in case you were wondering, in case it wasn't clear from the intro. Not the one who drinks blood and has toe thumbs. That's important. It's an important distinction. Okay, do you have liquor is the question, because you're going to need liquor. Yeah, so here's what I have. We're going to be watching Dr. Sally Smith. Now, who is Dr. Sally Smith? Well, she's one of my least favorite people in the whole damn world. She's a child abuse doctor. Now, if you don't know about these people, god dang, my glasses are so dirty. If you don't know about these people, these child abuse doctors, they are employed by the child welfare agencies of the world. And they are some of the dumbest, least educated, myopic, and malicious people in the whole damn world. And I'll tell you what, getting to have one of them deposed in front of me is one of the greatest pleasures in life, really, if you want to know the truth. I often joke that much like Sean McMillan, I too, my sexuality is, I think we should call it deposexuality, because I get turned on watching government agents getting deposed. That's where my sexuality is. All right. Whenever the government gets screwed, I get real happy. Yes, Sally Smith is the one that they've been talking about through this trial. We are broadcasting live right now on YouTube, on Rumble, on Facebook, and there's a live chat happening at meganfox.locals.com. If you are a subscriber over there at Locals, you can get in the chat and you can send gifts and pictures. You know, I'm really disappointed in the last group of you from the last stream. Very disappointed. Guess what nobody did? I asked for one thing, and not one of you did it. Now, normally when I ask for memes, you guys pull through. You come through. I asked you for one little meme last time, and I got nothing. Do you remember what meme I was looking for? I need this face next to the dog face in the meme about sex scandals. This is important stuff, and nobody answered the call. Take the screenshot, make me the meme. I don't know what's so difficult about that, but nobody did it. Usually you guys do it. I'm at Megan Fox Writer on Twitter, so you can find me there and send me funny things and memes and things. Or if you're on my Locals, you can send it in the chat, which is always fun. All right. We are watching Dr. Sally Smith. Now, I have been told that she is the embodiment of Miss Trunchbull. If you've ever seen Matilda, then you know what we're talking about. So if you haven't seen Matilda, though, maybe I should bring that up to give us a reference point so that we know what we're talking about. All right, hang on. Let me search Miss Trunchbull. Ah, yes. Oh, good God. I forgot how, and this is really accurate. I gotta tell you. Hold on. Let's pull this up.
After all, any school is better than no school at all.
Yeah, until she meets the principal. Okay, so where's Miss Trunchbull? Here she comes.
You, detention. You're too small. Grow up quicker.
You're too small. Grow up.
Heads up, shoulders back, stomachs in. Stand up straight.
Hey. Probably gonna hit me with some kind of copyright. How come we haven't seen her face yet? Where's her face? Where's her face? Ah, here it is.
Bull. Out of my way.
Here she comes.
All right. All right. So, shall we get over to see the embodiment of Miss Trunchbull in real life, starring in the Maya Kowalski trial? And here she is. They're not wrong. They are not wrong. All right. So, if you have not caught up on this case, let me give you a quick rundown. You should head over, by the way, to pjmedia.com, where I write when I am feeling up to it. Since my neck has stopped bothering me, I was able to write today. It took me several hours. But head over here and click on this article for me. You'll get some good background of what happened yesterday and where we are in the trial as of now. And we'll drop that in the chats on all the platforms. Oops, I forgot to drop it on Facebook. Sorry, Facebook. I never remember you guys because you guys are so quiet. The only people I hear from are my Rumble folks and my YouTube folks. Facebook is like super, super quiet. Anyway, go and click on this article. It helps me out. Clickety click. That is in order. And I want you to click on that and read through it because there's some good stuff in here about what happened yesterday. It's a good recap of the terrible things that were revealed about Johns Hopkins and their supposed care of Maya Kowalski, including a doctor who called her ketamine girl, this woman, and made flippant statements after her mother committed suicide. You know what? I can't I can't censor myself. I know YouTube wants us to, but it's just not something I can do. So if you are triggered by anything, really, you shouldn't be watching me. If you're the type of person who gets triggered in any way, please stop watching me, because I will send you into some kind of state. All right. I mentioned alcohol. Let's get back to it, because we cannot handle this face without some alcohol. So I was going to make a cocktail, and I was thinking about doing an espresso cocktail, like a latte martini or espresso tini or something. But it's really cold here in New York. So I decided to make a hot toddy, which is basically my favorite tea of the moment right now, which is a Bengal spice tea. It's like cinnamon and clove and all kinds of incredible holiday type spices. But for the alcohol, instead of putting cream in, I'm going to put in what do we have here? A Black Button Bespoke Bourbon Cream. And oh goodness, have you ever had this? Let's see if I can get some ASMR with the cork. Oh, cork is tough. Ah, that was a good one. Okay. All right, I don't have anything to measure this with. I'm just going to pour a couple glugs. Maybe another one. Yeah. So I already had the tea steeping in there for several minutes. And then you just add the bourbon cream, and you got yourself a hot toddy. Let's see. Smells good. Bad Weather Biker, I haven't seen you in so long. Where have you been? Thank you for the super chat, by the way. Can you believe I've been remonetized by YouTube? It's kind of a miracle. Bad Weather Biker says, heard the discussion earlier about not wanting to have a handsome OBGYN. I recently had some urinary tract issues. My urologist looked like Margot Robbie. Her teaching me how to self-catheterize was interesting. Oh no, it doesn't need another glug. No, it's perfect. Oh, is that so good? It's really cold in New York all of a sudden. We went from 80 degrees to 40 degrees, and I am not ready. My body is not acclimated. And I am just freezing to death. I am freezing to death in this office. I have a blankie on my legs. I've got this space heater on, and I've got the hot toddy in my Johnny Depp mega pint cup. See, it's mine. It's pretty used. It's pretty worn. The lettering is coming off. What is this bourbon? It's a Black Button label, and it's called Bespoke Bourbon Cream. And it is so good, you guys. It's so, so good. You can put it in coffee. You can put it in, I don't know, you can put it on ice. You can just drink it straight with ice, which is also very good. But yeah, this with the Bengal spice tea is really delicious. I am so addicted to that Bengal spice tea. I cannot stop drinking it with a little cinnamon creamed honey. Oh, so good. I've practically given up coffee for this tea. All right, let's get to it, shall we? Oh, before we watch Sally Smith, though, we have to watch the almost mistrial that happened first, because that's insane. So let's back up. But the defense is trying to pull a fast one with the first witness, and they get caught. I'm not going to go over whatever they're arguing about in the beginning. We're just going to start with the first witness, who is the child, was Maya Kowalski's guardian ad litem. Now, if you have followed any of my writing about family court and the corruption, I write a lot about corrupt guardians ad litem. A guardian ad litem is a court-appointed, supposed protector of the child. This person will be a lawyer. They will be someone who is supposed to look out for the best interests of the child. They're supposed to be a neutral party, but they are never a neutral party. They are always in bed with DCF. They are always cozy with authorities and with the court. I have yet to meet a guardian ad litem, save my own sister, who has been a guardian ad litem in court before. I've yet to meet one besides her that actually works for the benefit of the child instead of the benefit of their own pocketbook or the state. This one I think is less offensive than most that I have run into. However, she didn't do her job. She didn't protect the child. Let's listen to her testimony.
Kowalski during 2016 and the very beginning of 2017.
Yes, sir.
First question is, would you please explain to the jury what a guardian ad litem is?
We are there for the best interest of the child. So in a dependency proceeding, the court can appoint a guardian ad litem where we're not for the parents or for the state. We are an independent advocate for the child's best interest. And
that's what you're supposed to be. That's not how they end up being. You should go read all my work on the guardians ad litem in St. Louis, because they're a nightmare.
Specifically for Florida's guardian ad litem program, we're part of a three-pronged team where there's a child best interest attorney, there's the child advocate manager, which that's the role I was, and then there's also a volunteer guardian ad litem.
Is it fair to say that the guardian ad litem, your position, you're there as an advocate for the child?
Absolutely.
We'll talk about some specifics of your interactions with the Kowalskis in the hospital during this time. But before we go there, would you just briefly describe your educational background?
I have a bachelor's degree in psychology, and that's an associate's degree in liberal arts. That's it.
All right, and approximately what year did you get involved with the guardian ad litem program in Florida?
In 2016.
And how long did you work as a guardian ad litem in Florida?
I was about 6 months. I worked in the Third Circuit, which is Live Oak and Lake City, Florida. And then I transferred to Sarasota in July of 2016.
And you worked in Sarasota and that circuit for approximately 4 years?
Yes, August of 2020.
And after that, where did you move or go to work?
I moved to Waycross, Georgia, and I worked for a domestic violence agency for several years. And in May of this year, I took on the position as program director for CASA, which is, or Southeast Georgia CASA, which CASA is Court Appointed Special Advocates. It's very similar to what Guardian Ad Litem is in Florida. The only difference is we're not, we provide all the funding.
Wait! Been there, done that, says an associate in the dark arts. Is that what she said? Oh, that was good. Woo! You know, this hot toddy is doing its job. I think I can get rid of the blanket. I think I'm having a hot flash from the hot toddy. I'm turning all red. Plus, you made me laugh really hard.
Funding ourselves, but we follow the similar national curriculum that's called the National Gal CASA curriculum for everything we do.
So, when you were in Florida, you served as guardian ad litem.
I know, I hate to say this, Diane, but you can totally picture her at a Pride weekend, can't you? With the wait, I'm gonna get demonetized again. I didn't mean it. But I can see that on the weekends. I think like on her profile, her dating profile, it says enjoys spending time with my cats and attending pride parades. I'm sorry. I didn't mean it. YouTube overlords. I didn't mean it.
Yes.
And in Georgia, did you take on a more managerial role?
Yes, I did.
Yes.
Can you explain that to the jury, please?
I'm the program director, so I actually do have some cases where I'm the CASA advocate just because I never want to not be doing that. But for the most part, I supervise the entirety of the program and I write grants so that we can be funded.
With all that in mind, is it fair to say that you've been involved in this type of work, child advocacy, guardian ad litem work for the past 7 or 8 years?
Yes.
Let's move to your specific interactions with the hospital and Maya Kowalski, Beata Kowalski. Were there occasions on which you supervised phone calls between Beata Kowalski and Maya Kowalski?
Yes.
On how many occasions do you think you did that?
Either 2 or 3.
Have you had an opportunity to review the court order that was in effect for that time frame?
Yes, sir.
Is it your understanding? What is your understanding about who was appointed to supervise phone calls?
Myself and the case manager.
Who was the case manager?
Charlotte Laporte.
And how long did you work with Ms. Laporte?
Well, at that point, since July of 2016, we probably had some random cases together.
Right. So if I understood your testimony, there's 2 people appointed to supervise these phone calls,
yes.
either yourself or Ms. Laporte?
Yes.
Was there
Oh,
a
so not
time
Ms.
that you
Beatty?
would supervise these calls simultaneously
With
Ms. Laporte?
no.
Is it fair to say it was one or the other?
Yes, that was the point of adding me, because normally we weren't appointed to actually be supervisors of phone calls. We would just be observers, but the judge in this case did do that.
All right. Did you ever delegate your responsibilities or authority to anyone at the hospital to supervise those phone calls?
Oh, now they want to approach. What do you want to approach for? Why do we need to approach? She can't answer that question. Did you ever delegate your authority to anybody, to Miss Beatty, anybody else? Because I'm pretty sure it was Miss Beatty who was doing the phone monitoring and stopping Beata from speaking to her daughter about anything other than Shopkins. Remember that? Lots of don't let her speak. Oh my God, I'm still laughing about the degree in the dark arts. You guys are so funny.
The objection is overruled.
I'll re-ask the question. Did you ever delegate your authority to supervise these phone calls to Catherine Beatty or anyone at the hospital?
No, sir.
You did it? Then why
Let's
was
talk about the phone
Kathy
calls
doing it?
you did supervise. Can you explain the framework, the setup
power
of
surge.
how these phone calls occurred? Where were you?
If I go down,
Where
I'll
was
come
Maya?
back.
Where was Miss Beatty if she was involved?
Okay. I was remote in Sarasota and in my car specifically because that was the quiet space that I could find. And I had to call in to these through the hospital. And so it was facilitated through Miss Beatty, and she was with Maya, as my understanding.
All right. So participants on the phone calls then, again, would be yourself, Ms. Beatty, Beata Kowalski, and Mike Kowalski.
Yes.
I'd like to play for you what's in evidence. Have you had an opportunity to review some of these phone calls?
Yes, sir.
All right. We have bits and pieces of evidence. I'd like to play for you what's already been admitted as 2608 alpha, and it's about 1 minute and 10 seconds.
Okay.
Okay, I'm recording this phone call so everybody knows.
Okay, hi, Mommy.
Hi, honey. How are you, sweetie pie?
I'm hurting. I miss you.
I miss you so much too. I miss you so much every day, every single day.
You know how happy it makes me feel to hear your voice.
Same here. I miss you so much, and I am so happy that I'm finally able to hear your voice too. Yeah.
I hope you.
What did you say, sweetie?
I hope I can see you soon.
I would love to see you soon. I would love to see you soon. We just have to wait for the judge to make the decision, okay? As soon as he makes the decision, then I'll be able to see you. Okay?
Beata?
Yes.
Beata, we're not allowed to talk about the case, okay? Maya, honey, we're going to talk about what you've been doing, if you need any Shopkins or things like that, if you had nice visits with your daddy, but we can't discuss the case, okay, honey?
Do you remember that call?
Yes, sir.
Was that you interrupting the phone call?
No.
Was that Miss Beatty?
Yes.
And why did you let her do that?
Beyond that October 15th call, did you have additional phone calls? Were you supervised?
Yes.
Was Ms. Beatty present on those calls as well?
Yes.
Do you recall from the order any limitation on how frequently phone calls were to be facilitated between Beata and Maya?
Same objection, and also in terms of foundation and time.
Why don't you deal with the time issue, but otherwise overruled.
All right. You recall that you supervised several phone calls in mid to late November?
Yes.
All right. The court order in effect at the time, having reviewed that court order, was there any limitation placed on the frequency of the phone calls between Beata and Maya that were allowed?
No.
Was there any limitation imposed on the length of those phone calls?
No.
Did you make yourself generally available to facilitate phone calls as the supervisor under the order?
Yes, sir.
Do you recall a time that Beata had requested a phone call on Thanksgiving?
Yes, sir.
Did you make yourself available?
Yes.
Was that phone call allowed to happen?
No.
Why?
Because Miss Beatty's schedule didn't allow for that.
Oh My God. So what we've learned so far is that there was no limitation on how often Beata could talk to her daughter, according to the court, but it was dependent for some unknown reason on Beatty's schedule. And this one, the professor of the dark arts here, the guardian ad litem, was really the only one supposed to be monitoring the calls. And she could have facilitated it through whoever the nurse on duty was, I would imagine. She could just call the nurse's desk and have her patched into Maya's room, right? Or did they take the phone out of the room because she was being treated like a prisoner? But instead, she goes through Kathy Beatty, who decides to use these phone calls as a way to control the patient and control the family. Yeah, no, Beatty wasn't even supposed to be involved. And on Thanksgiving, Beata doesn't get to talk to her daughter, and her daughter doesn't get to talk to Beata because Beatty can't fit it into her schedule.
So Lovely. Ms. Beatty was not amenable to a phone call on Thanksgiving between Beata and Maya.
She just wasn't. It just wasn't in her schedule, from what I know.
All right. Do you recall a phone call after Thanksgiving?
Yes, sir.
Have you had an opportunity to listen to that phone call?
Yes, sir.
If that phone call is allowed to be played for this jury, do you consent to the playing of that phone call?
Yes, sir.
In that post-Thanksgiving phone call, did Beata Kowalski attempt to pray with her daughter?
Objection, hearsay, Your Honor.
I haven't asked for it.
Overruled.
Did Ms. Kowalski attempt to pray with her daughter?
Yes, sir.
What was Ms. Beatty's reaction to Beata trying to pray with her daughter? If you could explain that to the jury, please.
Well, the phone call was, Ms. Beatty had mentioned that the phone call, it was time for the phone call to end it because she needed to go to a meeting. And Ms. Kowalski asked to pray or began praying. And then at one point it was interrupted by a lot of loud noises. And Ms. Kowalski asked what the noises were. And Ms. Beatty said that it was her office stuff. And anyway, she proceeded to finish the prayer, and then the visit ended. And afterwards,
let me stop you right there.
Sorry.
You're doing great. I just wanted to clarify, when you say the visit ended, does that mean that at that point, after the prayer, which was slightly interrupted, that Maya and Beata both hung up?
Yes.
So at that point in the phone call, it was just Ms. Beatty at the hospital and yourself?
Yes, sir.
All right. Please continue.
So at the end of the call, Ms. Beatty said to me that that prayer was just the mom's way of extending the phone call. And I said, well, she has a right to pray. And then we were going to schedule, I asked her, can we schedule the next phone call? And Ms. Beatty said, no, we're not going to schedule anything right now. I'm going to end the phone calls at this point. I'm going to take care of that.
Holy crap. And I just want to point out here, good for her for telling the social worker that they had a right to pray, but badly done that she didn't report it to someone. Badly done that she didn't go to someone and say, hey, this social worker doesn't understand our guidelines. She doesn't understand civil rights, and somebody should be looking into that. And frankly, to have a social worker at the hospital then tell you, who works for the court, what she's going to do about the phone calls, and then you just allow that when it's the court mandating the calls? Weird that she didn't go to anybody. She just was like, okay, I guess you're the boss.
And as part of your training as a guardian ad litem, do you receive training on the right of families in these types of situations to maintain their religious practices?
Yes, sir. There's cultural competence training that includes all different aspects, including religion. And it's part of our goal as guardian ad litem to make sure that the child is having all of their normalcy needs met, and that includes any kind of religious practice.
And did you inform Catherine Beatty of this, the right to practice their religion?
Yes, it was a quick comment, but I did say, well, she has a right to pray.
And after Ms. Beatty stated to you that she was going to put an end to the phone calls, did you have any future phone calls where you were allowed to supervise Beata and Maya speaking?
No.
I wish they asked her, and did you report that to anyone? The violation of the civil rights? And the fact that the hospital social worker said she was going to put an end to the court mandated phone calls. I mean, the court order said she could have the phone calls. So this one social worker in the hospital is more powerful than the judge?
Your witness.
Good morning.
Good morning.
Just a few questions for you. So if I understand, I think I understand, so the jury understands the rule. The guardian ad litem program is the neutral appointed in the best interest of the child. True?
Yes, sir.
Okay.
So
There's
they
training
say.
that you go through. And then there was also somebody who was, I think you said,
Is this guy, is his name Shapiro? Is this the one whose name is Shapiro? I know one of them is Shapiro. I know who Hunter is. He's the one we were laughing at earlier, who had the very bad day. Oh, and by the way, he is in court. There he is, right there. So those of you who said he wasn't there, I think you're wrong. There he is.
volunteer that was assigned as well?
Yes, sir.
Okay. Do you remember who it was?
Yes, Sharon O'Leary Johnson.
Okay. And she would be someone working, is she working under you?
Yes, so I would be her supervisor.
Okay. And she reports to you, well, let me set the preface. I know you and I know what's going on, but I think for the benefit of the jury, let's sort of explain the role. So you would go to the hospital and visit when you could, right?
Yes.
And Miss O'Leary Johnson, as the unpaid volunteer, would also go as well, right?
Yes.
And they would file their observations of what they saw in the hospital in reports.
Correct.
And you would do that as well?
Yes.
Okay. You're not hired by All Children's. You're not paid by All Children's, right?
No, sir.
And you're not paid by the Kowalski family.
Correct.
You're the true neutral.
Yes, sir.
Okay.
True neutral, my ass.
And not to say you would do anything else, but actually you guys have to sign an oath to the court that you are going to advocate only in the best interests of Maya, right?
Yes, sir.
Oh, and guess what? No one holds them accountable for that. Yeah, they swear an oath. Big deal. You go and find out. Look at my reporting in St. Louis. Who are they accountable to? Absolutely no one. They get judicial immunity. The parents who tried to sue the guardians ad litem in St. Louis for the horrific violations of civil rights that they were put through, those guardians ad litem all got judicial immunity. So don't tell me they're neutral, and don't tell me they're not a party of the state. And don't tell me they always do the best thing for the child, because they don't.
And you make recommendations to the court based on what you see as well, true?
Yes.
Holy crap, that's his wife? All right, so earlier in the trial, so that's Shapiro, his wife was making inappropriate comments on a Maya Facebook group until the court got wind of it. She was kicked out, and then the court had to make her stop. This defense team is a whole mess. It's a whole mess. Purple Pros, I am so sorry. I am so sorry to hear this. I know there are parents like you all over this country being tortured by CPS. I am so sorry. And I believe you. I believe you. I've seen it too many times not to.
Yes, sir.
Okay. So let me ask you a little bit about, have you reviewed your notes?
No.
Okay.
One.
Got it. All right. So if you need to refresh your recollection, let me know. But do you recall that you first visited Maya at All Children's Hospital on October 14th?
Yes.
Have you reviewed that note?
That's the only note I reviewed.
Okay. If you need me to, would it be helpful to have the note in front of you to refresh your recollection?
Yes. That would be
Okay. May I approach, Your Honor?
You may.
And I do have an extra copy for plaintiff's counsel. Okay.
Look how eager
So
he is.
what I'm going to hand you for the purposes of identification is going to be defense.
Just want to point out that the last time we had an issue with notes, the defense was freaking out that Dr. Corcoran had his notes and was reading from his notes. Now suddenly they're just determined for this woman to have some notes.
Exhibit 3250, pages 1 through 4.
Diane.
I'm glad your glasses on because the type is very small.
I'm actually going to have to take them off for that.
Okay.
That's first thing probably.
All right.
She's like me. I have to take the
Do you want to take a
glasses
moment
off to read.
that one? Would it be helpful before I ask you questions?
He's making sure she reads through them thoroughly. So apparently reading notes is not really a problem for the defense until it is.
This note is computer generated by you, correct?
Yes.
And it shows in here that the date of the visit that you made to All Children's Hospital was October 14th, 2016, right?
Yes, sir.
And it says that it was a face-to-face meeting with Maya, correct?
Yes.
And it says that the meeting was about an hour and a half. Is that right?
Yes.
Okay. And then you made some notes on your meeting, right?
Correct.
Okay. In your note, Where was Maya at that time?
She was, let's see. Yeah, she was in her room, her hospital room.
Okay. Did the hospital ask you to come to the hospital and explain to Maya why she was being held at the hospital?
Yes.
Okay. And just for frame of reference, on October 14th, earlier in the day, you were at the dependency court, correct?
Correct.
And you made a note that the Kowalskis did not contest shelter at that hearing, correct?
Oh, holy shit. Hold on. Now they're in trouble. This just opened up a whole can of worms. And you heard what he just said. He said that the Kowalskis didn't contest the shelter at the hearing. First of all, the hearing and what happened in the DCF hearing is not at issue in this case. It has been made very clear by the judge that they are not to discuss the DCF case. And if I were to guess why the Kowalskis did not contest the shelter hearing, is probably because they were told by their lawyer. I'm just telling you what other parents have done. They were probably told by their lawyer not to fight DCF, because if you fight them, it gets worse.
It's not relevant to this case at all.
If you fight them, it gets worse. And so it's very possible that it was a legal strategy to not fight because they knew that they were going to take it anyway, right? You don't have to consent to a shelter removal order or whatever. They do it anyway. So it's possible that they were advised through attorneys to not fight it so that they could be seen as reasonable and the judge would hear them and they could get it straightened out. By Shapiro bringing this up in front of the jury, he has now just caused a cause for a mistrial. It's that serious. However, what you're going to see is Anderson doesn't really want a mistrial because he thinks he's winning after yesterday and today. And of course, nobody wants to go through this for another. I don't think Maya's family could afford it. If you had a mistrial now, you'd have to pay for this all over again and have a new trial. Yeah, this gets crazy, so pay attention.
You were asked by the hospital to come to visit Maya and explain to her why she's staying at the hospital. Is that right?
Yes, sir.
Okay. You made some observations while you were at the hospital. Is that fair?
Yes, sir.
Let me ask you about a couple of the comments in here.
He knows he screwed up.
Approach on a question before I ask it.
All right. He knows that he has screwed up. Now he knows how badly he stepped in it. Because now he probably just got told by the judge, how dare you say that? How dare you step out of line and bring that up? So now he's like, yeah, Shapiro tried to give it a whirl. Yeah, let's give it a whirl. Now he's scared to ask her any question because it's all relating to the DCF case and he is not supposed to do it. Now, the judge is about to get pissed and he's going to send the jury out of the room, send the witness out of the room, and then they're going to have it out in front of us. So let's skip over to that part because I'm not sure he comes back. No, they kick kicking the jury out. Judge comes back.
But in essence, the language.
Here we go. Let's go back and we'll hear.
I know.
Look at his face. Look at the judge's face. He's so had enough.
Ma'am, can I actually have you go sit out in the hall for a few moments?
He needs to have a come to Jesus meeting with the lawyers in the room. All right, the hot toddy is working. I'm getting overheated. Maybe I can make a cold cocktail now.
Present, so is the jury. Mr. Anderson.
As we explained to the court above, and again, for the record, by virtue of counsel having taken a DCF note, held it up.
I know you're not. Sorry, Mr.
By holding it up, showing it around the courtroom to the jury, referencing it as what it is, and then reading out sections. Admittedly, as we watched, yeah, there's some slight paraphrases, but in essence, the language of that note was being portrayed then to the witness. And in that way, the jury is now under the impression that there are notes out there that are contradicting everything the witness says and introducing the whole idea here, the concept of who was in control at what point, which is.
All right, hold on. I want to answer this question. What sparked the judge sending the jury out? Did someone say something again? No, but while they were up there in their sidebar, it was getting too complicated for him to do it at a sidebar, and he wants them to back off and make their arguments to him and put it on the record, most likely. I mean, it's on the record. The sidebars are on the record, but you know, he had to send the jury out for this because he knows this is going to be a while. So you send the jury to take a break. Yeah. Okay. So let's back up a little bit. Let's hear.
The direct violation under the impression that there are notes out there that are contradicting everything the witness says and introducing the whole idea here, the concept of who was in control at what point, which is a direct violation of this court's instruction that we are not supposed to be getting into that stuff. And the plaintiffs have been chastised, and I understand the court's position on those. But in this instance now, we have got effectively a published, or at least part of a published note in here on something the court specifically instructed us, the plaintiffs, and the defense was there not to do. And so we asked the court to take under advisement, because obviously with 5 years into this, we want to see a jury verdict here, but we asked the court to take under advisement a motion for mistrial in that regard. And we asked the court also to consider, if indeed this is the way they're proceeding, and at this point that the door has been opened for us to attack some of these notes and some of these positions and some of these actions that were behind the orders and DCF directions. So that is our position.
Well, let me be, are you or are you not moving for a mistrial? I need a clear, you are or are not moving for mistrial.
May I inquire from the court, if I may move as previously done here, to move for a mistrial, but have the court take it under advisement until the conclusion of the case, because I do not want to take a step right now that wastes 5 years of litigation and now 3.5, 4 weeks.
I am not in the position
look at Hunter.
What I might do on a motion you haven't made.
Then I cannot.
Wait, look at Hunter. Look at him.
5 years of litigation and now 3.5, 4 weeks.
Look at him. He's like, oh, God damn it, Shapiro. You fucked up big time. And now we're talking mistrials. None of these people have slept in 14 days. Like, they are up all night working, preparing for deposit, preparing for witnesses. Look at this man's face. Look at Hunter. Oh, man. Oh, this is good.
I am not in the position to give an advisory opinion about what I might do on a motion you haven't made.
Yeah, I don't understand that. So he's asking, Anderson is saying, I don't want a mistrial, but I basically want you to, I want to file a motion for mistrial for you to take under advisement after we get a verdict. I don't even know, is that a thing? I think you either have to ask for a mistrial or not ask for a mistrial. I mean, I don't think you can do that. AP, thanks to the super chat, says, look up Meet the Robinsons sock puppet uncle. Looks like the judge. Syllable lives matter. McCray H, thanks for the super chat, says, probably a dumb question, but I assume the jury would not be able to know they turned down a settlement, right? That kind of proves their case. Also, why is Evil Sally on depo and not in person? Okay, I can answer these questions. All right. I don't believe the jury is allowed to know that they turned down a settlement. But even if they did, it doesn't prove one way or the other who's guilty. It might make you think that someone's guilty, but when it comes to the hospital, there might be plenty of reasons why they would choose to settle a case rather than go through the expense of a trial, which is considerably more than what they probably offered in the settlement. And we don't know what the settlement offer was. I'm sure it was nowhere near $200 million. All right, your second question, why is Evil Sally on depo and not in person? I understand that the defense is calling her in person. That's what they said earlier in the trial. So if the defense is calling her in person, then the plaintiff has no reason to call her on their side. They're just playing, what they're doing is playing the best ofs of their, they've deposed her probably 5 times. And you'll see she's wearing different outfits and all the different clips that they put together. They basically put together clips of the best of the Sally Smith depositions. So he's still going to get to cross her live because the defense is calling her as a witness. And I am so sorry to tell you, I am so sorry to tell you, after watching some of Sally Smith's testimony, the defense is absolutely going with Maya Kowalski was an abused child and it was her mother's fault. They are going for it. That's what they're going for. Now that I know they're calling Sally Smith to the stand, and after watching some of her deposition, that's exactly what they're going with. They're going to try and prove that Beata Kowalski was a child abuser. I hate to tell you this, but that's what they're going to do, and it's going to make it really difficult. Because you can count on people in the law and crime chat who are uneducated on this type of situation with these type of people who are going to believe every word out of these lying medical snakes' mouths. They just are. They're going to believe them. Enchiladas Unbreaded, good to see you, buddy. Thanks for the super chat. Says, take my shekels. We appreciate your time. Well, I appreciate you. VV68, you're a newbie here. Well, welcome. I'm so glad you're here. Loving the commentary. I have to say this case breaks my heart. I have never been so disappointed in our healthcare system. Well, stick around because I have a lot more stories like this. In fact, I wanted to show you something before I forget, in case some of you are new to this and you have never heard of a case like this before, where mothers are being what's the word? Accused of Munchausen syndrome by proxy falsely. And let me tell you, it happens more than you would want to know. And I want to get over to an archived article that I saved, because this was something I wanted to write about a while ago. I just never got to it. And I wanted to, let's see, wait, I got to go over here. Oh, shoot, that's the wrong link. Where's the other one? Hold on. Here it is. Aha. In the same area in Florida in 1993, this is when I was looking for the other family that had another suicide at Johns Hopkins All Children's. I was looking for news articles on that family, and I came across this one that I had read before when I was researching this child abuse doctor in Florida named John C. Wright. Falsely accused mom tries to rebuild life. Roswell, Georgia. Even now, Angela Cochran sometimes wonders if people will believe her. 2 years ago, nobody did. She was accused of poisoning her baby, of being mentally ill, and of falsely denying it. The pediatrician in Fort Lauderdale believed it. This would be John Wright. He reported it to child protection officials. And John Wright, by the way, was involved in Cynthia Absug's case. The officials believed it. They took both of her sons away and pressured her into committing herself into a mental hospital. Her in-laws were uncertain. Her own parents were not sure. Her husband wondered whether it could be true. For a moment, she even wondered herself, could she have deliberately poisoned little David? Could she be so sick that she had suppressed the knowledge from her conscious mind? In the end, the answer was no. The pediatrician's diagnosis was wrong. She had not poisoned her baby. She was not crazy. I was totally questioned as a mother and as a person, she said last week in the living room of her new home in this Atlanta suburb. I'm gradually getting over that. Her husband, Michael, sat beside her. David, now 3.5, scampered around the room. Her older boy, Michael, the third, almost 5, played upstairs. The family is back together, but for 3 months in 1990 and 91, it was torn apart. The children were separated from the parents. Husband and wife reached the brink of divorce, all because of a terrible mistake. So the nightmare began in November of 1990 when they took 9-month-old David to Holy Cross Hospital in Fort Lauderdale. David had been small at birth and had endured medical problems since. He had been in the hospital 2 weeks earlier with bronchitis and 2 months before that for a hernia operation. His slow growth concerned doctors. That evening, he began to vomit uncontrollably. The family pediatrician, Dr. John Wright, told the Cochrans to bring David to the emergency room. The infant was very, very ill, Wright said last week, and the cause was not obvious, so he ordered tests. 2 days later, Wright told the Cochrans he had discovered the cause of David's problems. Angela was poisoning him. I looked at Angie and I asked, "Did you do this?" Michael Cochran said, and his wife was in shock. "I could not believe it," she said. "I thought he was going to take it back in 2 minutes." Wright did not take it back. He notified authorities, as he was required to do if he suspected child abuse. Oh, by the way, John Wright was writing a book on Munchausen syndrome by proxy, and he's also a speaker who speaks on Munchausen syndrome by proxy. He gets hired to give speeches. You think he was maybe just looking for one so he could write about it in his fucking book? And it gets worse. His diagnosis was that Angela suffered from a rare psychological disorder called Munchausen syndrome by proxy, in which a parent, almost always the primary female caregiver, makes a child ill in order to gain attention. Officials from the State Department of Health and Rehabilitative Services arrived. The officials told the Cochrans they had two choices: place their sons in a foster home or with relatives. They arranged for Michael's aunt and uncle to take the boys for 2 weeks. They informed Angela and I that we were not allowed in the hospital, Michael said. If we showed up in the hospital, they would put the kids in a foster home where we wouldn't know where they were. Neither parent was allowed to visit their children. The Cochrans asked what should they do. 2 days later, at the urging of HRS officials, she checked into University Pavilion Hospital in Tamarack for 2 weeks of psychological tests. John C. Wright, the doctor, invited Michael to Denny's for coffee. He gave Michael books on Munchausen syndrome and told him his wife was very ill. He very much wanted to write about Munchausen's, Michael said. He asked if the Cochrans would help him with an article. Can you imagine? Can you imagine the gall of a guy like this? Anyway, it turns out that he had claimed that the contents of the baby's stomach showed a substance that he thought was ipecac. And so he was sure that she had done it. But it turned out that he had a rare genetic disorder. Of course. I don't remember who got the diagnosis, but there was an analysis of his blood. He had an enzyme deficiency that can cause the child to become ill under stress. Wright withdrew his diagnosis of Munchausen syndrome by proxy. But HRS refused to return the children. How do you like that? It's like getting into a maze, he said, and you've got to get to the end of the maze no matter whether you've gotten the cheese or not. In March, on the eve of a trial in the Cochrane suit to regain custody, HRS dropped the case and returned the children. The agency was ordered to pay the couple more than $7,000. That's it? To compensate for the experts they had hired to prove Angela's innocence. The department later agreed to pay the Cochrans an additional $40,000 to settle a lawsuit. Boy, they settled for way too little. Way too little. So I just wanted to throw that in there and read a little bit of that to let you know that this is not a rare occurrence, okay? You can Google at any time false Munchausen syndrome by proxy diagnosis and come up with article after article about corrupt DCF and or stupid doctors or corrupt doctors or both who do this to people. Or don't forget to hit that like if you're here. I see 194 of you on YouTube. Those are some damn good numbers, folks. Good job. Thank you. And also on Rumble, don't forget to hit that that thumbs up, guys. And follow me on, hit that, what is that? Join button. The red join button on Rumble. Make sure you hit it. And follow me on meganfox.locals.com. Let's get back to the big fight that's happening, that happened today in the courtroom.
Then I cannot make it because I do not want in any
opinion about what I
litigation. And now 3.5, 4 weeks.
I am not in a position to give an advisory opinion about what I might do on a motion you haven't made.
Then I cannot make it because I do not want in any way to have this trial.
So to be clear, you are not moving for mistrial.
Under these circumstances, I am not moving for mistrial. I am, however, documenting for the record that the
Hunter's doing it again. He's got his hand in his face again. This is just going to be him for the rest of the trial.
extent of the damage done here is a basis for it, but I cannot move for a mistrial at this point based upon the circumstances of this case and a disservice to my client after all of this effort. So I just want to set that for the record.
One comment if I might. There was a representation made to the jury about the Kowalskis not contesting the shelter petition, which is damaging. There was additional representation made. That comment was made because something in this note comments on that. I've reviewed the note again. There is no commentary in this note on the failure of the Kowalskis to properly contest that shelter or consent to that shelter, however you want to phrase it.
Well, first off, is this document in evidence?
It is not, Your Honor.
Okay. Let me see this document. Just put it. What's the?
Oh my God. So let me get this straight. Shapiro picked up a document that had no reference to the shelter hearing in it at all and just fabricated that question out of the thin air. So it was intentional, is what you just heard.
Exhibit 3250-001.
What is this young guy's name here? We have to get his name. He's really quite good, and I forget his name.
And you make that note bigger.
I wish we heard from him more often. All right. I hate this note, but we're going to read it. I went to All Children's Hospital. This is by the guardian ad litem, or the the guardian of the dark arts, as we call her. Whitney. That's right. His name is Whitney, Mr. Whitney. I went to All Children's Hospital to visit Maya. First, I met with the hospital's social worker, Elena. Then Elena took me up to meet with the nurse and the physical therapist. She is in the regular room on the 8th floor. I then met Maya. The hospital wanted me to tell Maya why she couldn't see her parents at this time. We talked for a little bit, and Maya asked about her father and her brother several times. I explained a bit about who I was, and I supervised a phone call between her and her father and brother. The father was appropriate and loving. He answered her questions in an age-appropriate manner. I stepped out of the room and spoke with the father for a while, explained who I was. He said that it took a while for her to come out of that, referring to the mother collapsing at the shelter. Now, I just want to point out, folks, that in all the cases I've covered, when CPS or DCF takes children away from mothers and the mothers cry or have a reaction like Beata did, like falling to the floor when she got the notice, when they fall to the floor and cry, which is a totally normal reaction for a mother to have when someone is taking your baby from you, they will take that reaction and they will write about it in their notes, and they will call the mother hysterical. They would call her names. They will say that she is, it's so misogynistic, you guys. Notice how they talk about the father. He was totally appropriate. But a mother who collapsed to the floor sobbing, she's not appropriate. There's something wrong with her, because, you know, you're just supposed to be totally calm when the state comes in and removes your children from you. You're just supposed to be calm and accept that. And if you don't accept it, they use it against you in court. He also said, we saw what that did to her when speaking of the no contact order and the mother collapsing. Other than that, the father was very appropriate and respectful and grateful for this phone call with Maya. And let me just say, if as a mother, they came and took your baby from you and you didn't cry, they would also write that down in the notes, and they would say, she didn't seem to care very much that we took the baby from her. You can't win with these people. There isn't one reaction you could have that would be acceptable to them. Where was I? Other than that, the father was very appropriate and respectful and grateful. Oh, so it wasn't appropriate for the father to say it took a while and we saw what that did to her. It wasn't appropriate for him to say what the state did to my wife. That was bad what they did to her. That wasn't appropriate, because according to the guardian of the dark arts here, whatever the frick her name is, I don't know, the woke cat lady on the stand earlier. Other than that, the father was very appropriate and respectful and grateful for this phone call with Maya. Maya has a small frame, it seems. She's very thin, not a lot of color in her face, and she is shaky and weak. The PT said, and Law and Crime stupid logo is in the way, something, her sitting up for a minute at a time, and they have her standing, I don't know how, standing something to use the potty chair so she can bear weight on her legs. I think, well, not if she's bearing all her weight on the chair. She's probably using it like a walker. I think it's important to note that Maya only asked once about her mother at the very something of the visit. The whole rest of the time, she was asking about her father and brother. So do you see the guardian ad litem is insinuating she doesn't really love her mother? Notice it doesn't say anything about a shelter hearing. Thanks for the super chat. McRae says, it feels wrong enjoying this horrific chat show, but somehow you make it fun. Also, thanks for the $10.
The question was now, maybe we can have the court reporter.
Says, I'm so lucky this didn't happen to us. A friend's ex-revenge called CPS on us for some made-up BS. She luckily saw right through it and testified word for word what we told her at their custody trial. Yeah, you're lucky she didn't decide she just hated you. Because if she decided she hated you, she just makes shit up. And then there's nothing you can do. Nothing.
Ask it again or read it back. The comment or the question that you asked, which was not, I don't believe it was answered, and then ultimately I gave an instruction for them to disregard, was something about her note indicating that the Kowalskis consented to the shelter proceedings at that court hearing.
I believe I asked. Well, anyway, go ahead.
Can we have the court reporter read back the question that right before we went to sidebar that started all of this?
Yeah.
Can we have Shapiro's dumbass question, please? Hunter looks like he's going to have a heart attack. He does not look good over there. The judge is doing some heavy breathing also. I don't know if you hear that, but he's going... I wonder, Hunter looks like he wants to strip off Shapiro's pants and give him a caning right there in the courtroom.
And you made a note that the Kowalskis did not contest shelter at that hearing.
Was there an answer by the witness?
Yes. At the same time as the judge.
I apologize, Your Honor. It was because her note says that she just came from the hearing. I was trying to set the table, and I thought it was because the plaintiffs opened the door to the orders, the interpretation, and the no contact that was entered. That was the purpose for going through. I will stick my questions for this witness only to their observations at the hospital going forward.
All right, I'm sorry. Let's hear that again. I want to hear his explanation for this shit show again. One more time, Shapiro.
To the I apologize, Your Honor. It was because her note says that she just came from the hearing. I was trying to set the table, and I thought it was because the plaintiffs opened the door.
I was trying to set the table, and I thought the plaintiffs opened the door. And I mean, how many more excuses can he fit in there?
To the orders, the interpretation, and the no contact that was entered. That was the purpose for going through. I will stick my questions for this witness.
He's not letting the judge answer. He just keeps on, for this. I will stick my questions for this witness to the stuff I'm supposed to say and not the stuff I'm not supposed to say. Diane Kelly says Shapiro will be walked out with security in his computer box of belongings. I mean, first his wife with the big mouth, and now this.
Only to their observations at the hospital going forward. Going through. I will
Verbal
stick my questions for
diarrhea.
this witness only to their observations at the hospital going forward. It was.
The judge is still heavy breathing. Do you hear that? Listen, he's breathing like a bull.
Only to their observations at the hospital going forward. It was completely unintentional to make that reference, although with the way the plaintiffs have opened the door to this throughout the trial. But all that being said, I apologize for the comment if it was made out of context, and I will stick to our observations at the hospital.
The judge is speechless. The heavy breathing. That could be Anderson. That might be Anderson. I think he's doing that breathing.
The
judge is being totally silent. He's still, his silence keeps making Shapiro continue to try apologizing in a different way. Oh man, this is the third attempt. I apologize. Of course it was intentional. He's full of crap. Thanks, Marliar. I appreciate that. There's no way that wasn't intentional. He wanted the jury to hear that the Kowalskis did not contest the shelter order. But I'm sure there wasn't a legal reason for that. The judge is seething right now. He can't even start talking.
Since I don't want to step.
Let's go back to that last pause. Listen to this pregnant pause. Wait.
We'll stick to our observations at the hospital. If I may, since I don't want to step in any more hot water on this, the plaintiff did.
I don't understand how that question was asked based on this note.
Oh boy. Oh
given
boy. Oh boy. When the judge says, I don't understand how that question was asked on this note, it basically is like him saying, I don't believe you. I don't believe your line of bullshit.
And given the nature of the defense, let's not talk about the dependency. Let's not talk about the dependency for years. Let's not talk about the dependency. You misrepresent a note on a question that you know can't be asked.
My apologies.
Holy crap. So the judge is like, you're the ones who don't want to talk about the dependency. You're the ones. If you notice, it's always been the defense. Like, we can't talk about the dependency. The hospital's not, they're immune from the dependency. We're not talking about the dependency. And then for you, Shapiro, to bring up the dependency and misrepresent, the judge uses the word misrepresent. Oh, he's pissed. It's just too bad he doesn't hold him in contempt. Man, I would like to see a judge use those powers for good once in a while. Loving to lime, sitting in the bathtub, eating grapes, watching Megan. You're my kind of girl. I love bathtub YouTubing. I watch YouTube in the bathtub all the time. I love it.
Apologies, Your Honor.
Oh, what do they mean by the
There's
dependency?
No motion for mistrial.
They mean the dependency means the court action that took custody of her. Okay. It took a dependency is like, you're now the child is now dependent on the state instead of on her parents. Okay. They call it a dependency hearing to find out who is going to have custody of the child. It's basically just referring to a custody hearing. And it was the defense who didn't want to mention any of it. And then he goes and brings it up. Oh yeah, that's as close as you can get to calling him a liar, is for sure. He just said you misrepresented the question. He sure as shit did. Okay, I don't know if this is true. I think the judge has given both of them a lot of leeway. I mean, Special K thinks that the judge was easier on the defense's mistake than on the plaintiff's mistake. I saw the plaintiff's mistake in the beginning of the morning yesterday. We didn't play it here on this channel, but you could have watched it on Rob's. I told you to go watch it on Law and Lumber. There was a big fight in the beginning because the plaintiff decided not to call a witness. And they didn't tell anybody till they were on the record that morning. They could have sent an email at midnight or whenever to the defense to let them know, give them a heads up. You don't have to be prepping for, this witness because we're not going to call him. And the judge was pissed. And the judge was so pissed he had to take a break and go out of the room. But was he harder on them? Nothing happened to them. He didn't give them any sanctions. He gave them a few harsh words, and he's doing the same thing here. My mic volume. Oh, because I have it boosted. So hold on. Hold on. I'll turn my mic down. I have the volume boosted for the court and that messes with my audio. So I will turn it down. Okay. How's that? Is that better? That should be better. All right.
So
we'd like to discuss with our appellate counsel what an appropriate curative instruction would be if we can come up with one.
And also, we're trying to document for the record the seriousness of this. And we're aware of the second district law on the necessities here. We're in a box. We would ask the court's indulgence to give us the opportunity at some point in the very near future to discuss this with Mr. Tanner, Mr. Elegant, and determine what the best approach is. And also our clients, who are not in the courtroom at this moment. At least I don't think they are. And so, but now that the jury thinks that we're consenting to all this. I can't imagine anything more damaging.
Well, I will give you time to discuss with Mr. Elliott and your clients what we're going to do. My suggestion at this point, and maybe you need to take a couple moments, is that we just continue on. Again, to be clear, the plaintiffs have not opened the door by talking about whether there was that delegation in the specific time. I know you disagree.
Look
but
at
that's the
Hunter.
court's ruling.
I
And
understand.
you have to live with the court's ruling.
Look at him.
So
And my
you
apologies.
can't.
I humbly apologize, Your Honor. I believe they had opened the door by talking about what the order said, who was responsible, who was allowed to contact who. But I apologize.
As a reminder, I mean, we've been, and I know you weren't there for so many of the hearings and you kind of came in to this late, but we've always talked about before you do something that is possibly out there on come talk to me ahead of time. You didn't do that.
I agree, and I did it the second time. So before the witness comes in, just so I don't.
I did it the second time.
There are
Too
3 notes
late.
written by the guardian ad litem regarding their observations of Maya at the hospital. May I inquire of this witness what the observations of the guardian ad litem were? And then at the end of
Absolutely, at the hospital, sure.
Yes, and then just again, so I'm approaching this, I'm treading as gently as I can, Your Honor. At the end, there's a guardian ad litem report to the court. Can I phrase my question in terms of, well, let me ask Your Honor this. The report is titled Recommendations and Observations of the Guardian ad litem. Do you want to start talking about the dependency action? Does the defense want to talk about what happened in the dependency action? No, but that's why I'm asking you, can I ask this witness about what the only the part about in the report, and I'm happy to hand Your Honor a copy. Because again, I want to make sure I don't, and there's an extra copy for plaintiff's counsel. There's a section on
Can we put this up and just
yeah, sure. It's
make it
defense
bigger
exhibit
so I can-
3258-001.
3258-0001, and this is not in evidence?
No, Your Honor.
Okay. And what provision do you want me to look at?
Section 3, observations of the child.
Can you make that larger?
Oh, wait, I haven't read this one.
Okay.
The guardian ad litem last visited Maya on January 4th. Per Maya's request, the guardian ad litem helped her put on her shoes. Maya's feet turned inward, but she was able to straighten them in order to slide her foot into her sandal. Maya initially stated that she was in pain, but never mentioned it again. From the perspective of the guardian ad litem, she did not appear to be experiencing pain. Maya had a scratch on her face and one on each hand. They looked like they were healing. The guardian ad litem attempted another visit on Saturday, but Maya had already been discharged from the hospital.
This looks like an observation that was made at the hospital.
Correct, Your Honor.
I have no problem with you asking what this witness saw, what she saw of Maya at the hospital. If she doesn't remember and she needs something to refresh her recollection, certainly you can refresh her recollection with this, but it's not going to be shown to the jury.
I understand, Your Honor. That's why I brought extra paper copies.
Well, Your Honor, this is a pleading to the court. We previously had a lengthy discussion, and we have a motion pending for reconsideration of the BD email, which was not even to the court. It was an internal email with recommendations and observations, and that evidence was excluded. And so we have to object because now they're allowed to put an observation.
Sir, you're misunderstanding what I'm saying. For purposes of refreshing someone's recollection, pretty much almost anything can be used. And if this, you'll call it a filing in the court file, if this filing helps refresh the witness's recollection, assuming she needs it, she might not need it. Assuming she needs it, then that's fine, but it's not being shown to the jury. It's not going to be referenced to the jury. It's just the document that she's using to refresh her recollection. So,
as long as they're not waving it around and keep it away until.
And Mr. Anderson, I mean, that's, you were making statements that Mr. Shapiro was waving the document around. I disagree with the characterization. Mr. Shapiro was standing at the lectern asking questions presumably from the document. He was not showing the document to the jury, and frankly, given how small the type is, and the distance from the lectern to the closest juror, even if he was holding it sideways, which he wasn't in the face of the jury, I don't think there's any reasonable belief that the jury would have been able to, with that much acuity, figure out what the words on that page were.
and I tend to agree with the court that unless we have falcons in the jury, they're not going to be able to spot that type. The one thing that I was concerned about, and I agree with virtually everything the court said, except he was holding a paper up here like this at the time that this started.
Standing at the lectern.
Standing at the lectern, but holding a piece of paper and obviously looking down, looking back up, looking down, looking back up. It does not take much to discern that this was some sort of official document, official report, because that's the way it was introduced. And so it appeared to me, at least, that he was holding it, reading off of it. He did set it down then, just for the record. And I think that that implies to the jury that there is some official document out there that this witness drew up or submitted to the court or to DCF, but in some way this was something official rather than for the use I understood he was starting out for.
Well, I think we just need to move on. I will give you time to discuss with your client and appellate counsel. So by the time we're finished with lunch today, I want to know whether you're moving for a mistrial or not, if you're asking for a further curative instruction or not, and what that is. If there's going to be a curative instruction, please get Mr. Altenburn and Mr. Elliott and Altenburn together on it, and we'll address it after we come back from lunch. Okay.
I have one more comment, and it's based on the allowable questioning that's coming. You were just a moment ago told there were 3 notes by Jessica Blackrick. I'm sorry if that's not what you said. Well, I would object to questioning because there's 5 notes in total, and 4 of them were authored by Sharon O'Leary Johnson, who she just testified was the volunteer guardian ad litem, not Ms. Blackrick. So if he's going to be asking questions about personal observations at the hospital of Ms. Blackrick, fine, but I don't think it'd be proper to ask Ms. Blackrick to comment on what Sharon O'Leary observed in the hospital. If they want to call her in their case to have Ms. O'Leary Johnson comment about her observations, fine. I don't think that's appropriate for this witness.
Well, I'm assuming we're not moving these notes in.
I'm not, but Ms. O'Leary Johnson reports to Ms. Blackrick, and these reports are filed with her. I believe I should be able to ask her, were these the observations of Ms. O'Leary Johnson of my at the hospital as reported to you?
What is the hearsay exception that applies?
She would sign off on these as her supervisor at the end of the case.
No. So, no, you can't. If you want to get, is it Miss O'Leary Johnson's observations, you can call her. Okay.
Then the observations of the child, then I'm going to be relatively brief with this witness, in this report are signed by her.
Who's her?
Miss Blackrick. And I'm trying to tread carefully without mentioning this is the report to the court.
Did this witness lay eyes on the child on, was it the 4th of January? It was 14th of October. I think the note that I was looking at talked about January 4th. The report to the court. Yes.
Oh.
Let's make it easy. You can ask about what this witness saw when she was in the hospital. But if someone else told her what that other witness saw, you can't ask this witness about what someone else told her what they saw.
Yeah, I understand that there'd be a way to get that testimony in through her, but I'd have to move the notes and evidence, which I can't do right now. So we might just do it through O'Leary Johnson. I understand that.
Well, the court will, maybe we ask at this point, although we'll need a curative instruction or the alternative, that at least at this point that the jury be instructed to strike the question is stricken and any response should be, I don't want to draw more attention to it.
Well, that was exactly what I was thinking. I already told them to disregard the question, and I said it was not relevant to this case. I already said that, and that was immediate.
Yes.
If we're going to do something else, and I'm not saying we are, I'm just saying if, I only want to do it one more time.
Got it.
I don't.
If they're going to do anything, if you ask me, I mean, I get where Anderson's coming from. You don't want to call more attention to it. Maybe the jury missed it. Maybe they missed the importance of that. But what if they didn't? What if they are left with the impression that this family is lying to them because they didn't fight the dependency hearing? I think I would ask the judge to allow me to explain that the only reason, like you may have heard, I think it should be in the, you may have heard that the Kowalskis did not fight the dependency hearing. They did this on advice of counsel, not because they were not not because they didn't contest it, but because it was a legal strategy in order to get her back. I think that's the least he can do, is explain it to them, because otherwise it prejudices the jury against the Kowalskis, if you ask me.
I don't want to keep doing 2 or 3 instructions on something.
In retrospect, I do agree with the court on that. I don't want to emphasize it anymore.
Ready to bring the jury back in?
1 minute, Your Honor, please.
Do you all need to take a couple minutes before to regroup?
If you don't mind.
Let's take a 5-minute break.
Hey, Marta. Welcome, Marta. Glad to see you here. She says, I'm new here, but love the vibe. Well, it's a good vibe. I hope you have a cocktail, because you're going to need it when we get to Miss Trunchbull. Oh, Tanya says, I mean, Shapiro definitely gave it a whirl. Fell flat on his ass, but a whirl was given nonetheless. Oh, we are never, ever, ever going to forget the whirl, are we? All right. Let us move forward. I think there's only a few more questions for the guardian ad litem, or the guardian of the dark arts, as we've taken to calling her. I don't know what her name is. I guess we should probably find out. They're talking amongst, they're sidebarring again. I'm really going to miss the depth sidebar dramatic readings when they're over. Tell you what. I keep hoping Nick will join us one of these days before we finish. Gosh, this is a long sidebar.
Thank you. Have a safe. Okay.
Okay.
Thank you. Have a safe drive back. You have to come back. Okay. So the answer is yes, you can go back, but at some point you might have to come back.
Wait,
So,
did we?
but the lawyers will be in contact with you.
What did they decide not to
Thank you. Have a safe drive back.
question her after all that?
And Mr. Anderson, Mr. Whitney, your next witness, please.
What did I miss? Did they decide not to question her?
One more question.
Correct. Correct. Received no information about, and that since you were last with us, you have not seen any media coverage about this case. Is that correct? Thank you very much.
If I may proceed, Your Honor, my sincere apologies. I just have one more question for you at the bench.
Oh, look at his face. Look at the judge. Oh, God. Okay, fine. All right. So then I guess they decide that they aren't going to question her anymore. That's it. I guess she's done. This judge is got to be so pissed by now. Like, are you serious, people? Look at Anderson's face when he walks away from the bench. Watch Anderson's face. We'll pause it on his face. Look at this. Watch his face. Watch Anderson. Here he comes. He just gave the side eye to the jury. Was the jury watching that? He's like, I don't know. I don't know.
Okay. Members of the jury, most of the questions that you presented, I'm not going to be able to ask. But the question I can ask
3 questions.
is, ma'am, the jury wants to know, was Miss Beatty always listening or included in all your calls between Maya Kowalski and Beata Kowalski?
Yes, sir. She was the point of contact for scheduling and facilitating the phone call to happen, and she was on it then.
Okay. Thank you. Mr. Anderson, anything further? Or sorry, Mr. Whitney, I apologize.
No, nothing further. No, nothing further.
And may this witness be allowed to go back to Georgia?
She can, although we'd like to not fully release her.
Okay, so the answer is yes, you can go back, but at some point you might have to come back. So, but the lawyers will be in contact with you about that, okay?
Okay.
Thank you. Have a safe drive back.
Wow.
And Mr. Anderson, Mr. Whitney, your next witness, please.
Dr. Sally Smith by video deposition.
Okay.
And just to inform the court, I'm told there's 5 different tapes. We'll have some breaks here.
Okay. Watch this. I did.
All right, here we go.
Alexis, 20% down, 20% up.
Here we go.
I went to school for
Dr.
that.
Sally Smith. All right, I got to warn you, my computer appears to be doing the freezing up again. So I have a problem with my computer. If my screen freezes, I have to reboot and I'll be right back. So most of you who are regulars here, you know the drill. entertain yourselves. It'll be like 4 minutes and I'll be back if I have to. Hopefully it will just write itself. All right, the courtroom's got a little atmosphere going on. They lowered the lights. Time to dim the lights and bring on the doctor, Dr. Sally Smith.
Would you raise your hand, please?
Or Miss Trunchbull, as we like to call her here.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
I do.
State your name for the record.
Sally Marie Smith.
And you were a pediatrician working for the state in the case of Maya Kowalski. Is that true?
I was the medical director for the child protection team, providing a medical evaluation for Maya Kowalski, yes.
Following medical school, what did you do?
I did a pediatric residency. I did a year and a half of residency training at All Children's Hospital in St. Petersburg from 1984 to the middle of the end of 85. And then I transferred back to St. Louis University at Cardinal Glennon Children's Hospital. And I did the remaining year and a half of my pediatric residency there and completed that in 1987.
In your residency program, how long did you spend, and you rotate through a number of different areas, do you not, in your residency? All right. How long did you spend in pediatric psychology or psychiatry?
I, again, did not look at my transcripts before I came here. I really have no idea specifically. I'm sure we had training in pediatric psychology and psychiatry as part of multiple components of the residency program, but I don't specifically remember like how many weeks or if I did a specific rotation or something like that.
Okay. And do you remember any of your professors, or I guess they're doctors that are also adjunct to the medical school that you were working with? Or we just, I'm trying to figure out the setup there. And my question really is, were there any doctors who are also professors that specialized in pediatric psychology or psychiatry that you worked with over this residency?
I don't recall.
Okay. After your residency, what did you do?
Those are some serious eyebrows.
I did an additional year of fellowship training in ambulatory pediatrics at St. Louis University.
Angry face than I do.
Hospital.
What does ambulatory pediatrics involve?
I've got a line right here from frowning.
It was.
She's got 4.
Fellowship in, ambulatory is people who are not hospitalized, essentially. And so I worked in clinics with various mentors.
We're going to speed up the background.
To essentially teach academic pediatrics in the clinic setting. I don't recall that I did any specific inpatient work as well.
What is academic pediatrics?
Pediatrics that is sort of focused on education and training of medical students and residents and interns, and in many programs in academic medicine, there are also research components to the work.
The past 17 years, you worked at Suncoast Center in one form or another, correct?
I don't believe so. I don't think that the Suncoast Center has held the child protection team contract that entire time. There was another agency called Help a Child that held the contract from the Department of Health when I initially became the medical director. I've worked with the child protection team since 1990.
Okay. So when it says medical director at Suncoast Center, child protection team, were you working for Suncoast Center from 2002 to the present?
I've been the medical director of the child protection team from November 2002 to the present. I probably should actually say Department of Health rather than Suncoast Center, because Suncoast Center is just the agency that holds the contract.
Okay. Well, Suncoast Center started at ACH in 1979, did it not?
No, that was the child protection team, not the Suncoast Center. I'm going to guess it was around 2007, 2008 that the Suncoast Center took over the contract for the child protection team, but I don't remember exactly when that was. I'm not sure, sort of what corporate name was, signed or that kind of thing. When I worked with the child protection team in 1990, it was, their signage and things said Suncoast Child Protection Team.
Okay. Well, when did you return to All Children's Hospital after, I think you were at University of Medicine, Dentistry of New Jersey, New Brunswick, New Jersey from 88 to 90?
Correct.
And then you were back at All Children's Hospital, it says a staff appointment from 1990 to present?
No. Well, my active medical staff, yes, has been 1990 to the present. I was employed by the hospital from 1990 to 2002.
Okay.
In the general pediatrics division.
So you went residency for a period of time, then you left, then you came back and started with ACH?
In 1990, when I moved back to Florida, I took a faculty position with what was then All Children's Hospital, yes.
Would you agree with me then that you do not hold yourself out as an expert in pediatric psychiatry?
No, I do not.
Would you agree with me then that you do not hold yourself out as an expert in pediatric psychology?
I do not.
Would you agree with me
this is
then
important.
that you do not hold yourself out as an expert in pediatric neurology?
No.
If you missed that because it was going too fast, he asked her, you're not an expert in child psychiatry. You're not an expert in child psychology, right? Nope. You're about to find out how little she knows about anything.
I mean, you're agreeing with
I
me.
do not.
Would you agree with me that none of these, none of your training has involved an in-depth analysis of the diagnosis and treatment of RSD or complex regional pain syndrome?
I agree.
Now, at the very bottom of 33, the next to last couple lines is, the purpose is to solicit the medical director's opinion first, and then the statewide medical director's opinion, only if this is not sufficient. See that?
You're asking me if it says that?
In Maya Kowalski's case, was the medical director's opinion, was that you, or was there somebody above you, a medical director, whose opinion you could seek? Now, at the very bottom of 33, the next to last couple lines is, the purpose is to solicit the medical director's opinion first, and then the statewide medical director's opinion, only if this is not sufficient. See that?
Yes, I see it.
And who's the medical director there?
That would be me.
Okay. And then the statewide medical director's opinion.
Yes.
Was that ever, in Maya Kowalski's case, did you ever seek the statewide medical director's opinion?
I did recently, but I don't recall if I did at the time of the evaluation or not.
Tell me about who that was recently or is recently and what opinion you sought.
Dr. Bruce McIntosh reviewed the file. And I didn't personally seek his response.
She doesn't need any supervisors.
Report here real quick. Hey, Tate?
Yes.
All right. So
the only thing that would make this better for me, though, is not having it edited. I would like to see the entire thing, and I doubt it'll ever be released in its entirety, which is why I love watching Sean McMillan's YouTube channel. I'm going to give you guys a push to go over there at Caps and Stems Law and subscribe over there, because Sean puts his entire depositions of these CPS freaks and DCF child abusers up online so that you can watch him tear them apart bit by bit, hour by hour. And it is satisfying. It is the most satisfying thing you've ever seen. So that's the only thing that would make this better for me, is if it was the entire thing. I don't like the editing. To me, it cuts off too fast.
Electronic medical record. What does that mean?
Well, as an active medical staff member.
Back out your tongue there. You're choking on your lies there, man. See that again.
Well, as an active medical staff member for all children at Johns Hopkins All Children's Hospital, I have access to the electronic medical record. So I reviewed that. Many documents from that medical record in compiling my report and reviewing the case. I did not print everything, so what you received of my medical records that have Johns Hopkins All Children's headings on them would be what Dr. McIntosh received.
All right, I'm going to go make a whiskey sour, I think. That's what I'm in the mood for, and now that I'm all warmed up. So I'm going to leave you with this. I'm going to go and do that. I'll be back.
All right. So Dr. McIntosh, according to you, received the medical records of Dr. Kirkpatrick. Is that right?
Yes.
Dr. Hannah.
Yes.
Is that right? Dr. Barr. Is that right?
Yes.
Dr. Wassenauer. Is that
Yes.
right? He did not receive records from Dr. Chopra. Is that right?
Not to my knowledge.
Or Dr. Cantu?
I was never able to obtain records from Dr. Cantu, so I don't have them and did not have them to provide to him.
And so you were familiar with the fact that Doctors Hannah, Kirkpatrick, Barr, and Wassenauer all diagnosed or concurred with a diagnosis of complex regional pain syndrome, right?
That appears to be correct.
Tell the jury whether you believe that every mother that fails to remember to tell a new treating physician the entire medical history is committing an act of child abuse.
No.
Tell the jury whether you believe that every mother that fails to follow the directions of the doctor or the prescription to the letter is committing an act of child abuse.
No.
But in this case, you believe that Beata was.
Upon review of all of the extensive medical records, review of all of the observations of the child in the hospital, review of the, let's say, unconventional treatments, including hyperbaric oxygen treatment and high-dose ketamine treatment repeatedly, it was my opinion that there was ample evidence to support a diagnosis of medical child abuse. And it appeared most likely that Mrs. Kowalski was the primary one who was resulting in, or I don't know what the term is, it's not probably instigating, but initiating or whatever, the child abuse. Perpetrating the child abuse, let's put it that way.
Just the prednisone issues, the stuff we've been going over the last hour. Do you think that was an act of child abuse?
There was an element combined with everything else of child abuse in the prednisone utilization and administration to the child, yes.
Other than this case, have you ever testified in court or by deposition in a case involving CRPS?
No.
Expert in pain management?
No.
Okay. Did you ever have a conversation with Dr. Kirkpatrick at any time in 2016 in which he offered to have you come over to his office and he would demonstrate to you with Maya or with another patient the testing that could be done to objectively determine the degree of pain a patient was in?
No.
You never talked to him about that?
No.
Okay. Did you have a conversation with Dr. Kirkpatrick in which he told you not to move forward with Munchausen by proxy or another allegation of child abuse?
I do recall that he made some such recommendation to me. I don't recall the exact words.
Did he express to you that there was an organic basis for this child's pain?
I don't remember specifically that he, spelled that out. I remember, at least in general terms, that I asked him about incongruities in the child's presentation, and he reported that was a manifestation of allodynia prior to touch, conditioned to expected pain from human touch, and that there was a fear of pain component that explained the child's way that she was moving around and touching things and doing things, but then couldn't do those exact same maneuvers when a physician or a therapist asked her to do so, or things were touching her skin, and then when somebody had a light touch on her skin, that she would scream in pain when a similar amount of touch was not triggering that kind of response. So I remember that he and I had some discussion about that phenomenon. A fear of pain component can be explained, and therefore it was my impression that he was telling me that information as a way to indicate that there was no other possible diagnosis in the case, perhaps.
All right, I opted for a beer instead of a whiskey sour because the computer was acting up and I didn't have time.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
My God, that's an ugly shirt.
A physician at Johns Hopkins All Children's Hospital, examine Maya and note that she is not in any pain.
That was his assessment that day, yes.
And that she is not moaning, she is smiling, she is interactive, she is very engaged. Is that what he found? Is that what he found?
That's what he has documented in this note that references his examination of her when she was at his office on May 11th with her father.
And at the bottom of that narrative, he says extremities show no clubbing, right?
That is correct.
What is clubbing?
So that is an abnormality of the distal fingers, essentially the area of the fingernails where the nail bed gets enlarged, and the fingernails often have an enlarged size across the tip of the fingers, typically related to chronic hypoxia or respiratory insufficiency.
It's also a specific symptom of RSD, complex regional pain syndrome, is it not?
Not to my knowledge.
Yeah, the lower register vocal fry is just as bad as the higher register vocal fry. Not to my knowledge. Not to my knowledge. And the complex regional pain syndrome. Good God, woman.
Okay.
Stop
but you're not
it.
an expert in it, right?
I'm not an expert in complex regional pain syndrome.
And then he says she moves spontaneously in her wheelchair without incurring pain, right?
Yes, as was observed on other occasions.
Do you consider tachycardia to be an abnormality in
Oh,
a
this
child
pisses
this
me
age?
off.
It can reflect many, many different conditions in the child.
Well, what is tachycardia?
A fast heart rate.
Okay. In last deposition, you said that a fast heart rate would be an indication of somebody being in pain, right?
It could be.
But you put no abnormalities noted on her exam. That's not really true from the actual record, is it?
Again, you probably should ask the person who made the documentation. They may be referencing that contrary to most cases of complex regional pain syndrome, she did not have any color change of her extremities, sweating abnormality.
We saw the pictures of the color changes on her legs. There are photos of it.
Deformity of her extremimies that would provide objective evidence to support her reported diagnosis.
Like
I'll
dystonia?
show you what has been marked as exhibit. Dane.
Trying to find a date on this. 10/7.
And I'll reference you to, and I folded it over, the physical examination found on page 6 of 9, which is PLT 4074, and I highlighted under cardiovascular. Can you identify what that is first?
What did I miss
15
on
is.
Rumble? Why is the Rumble chat talking about boob size? What is going on over on Rumble? Hold on. I have to check. The girls over on Rumble are comparing bra sizes. I don't know why. Oh, because she has big boobs? Is that it? You guys are funny. Are you guessing the good doctor's bra size? That might be a little bit too far.
So this is the emergency center physician notes. I don't know, probably dictated by Dr. Bahar Posey in the emergency room.
Oh, this pisses me off.
I'm sorry, what was the question?
Under the physical exam, does it note that under heart rate, she is tachycardic?
It does, and it states that her pulse rate was 134.
That's very high in a child of this age, is it not?
Well, 250 would be very high. It's elevated at 134.
Okay, that's not normal, is it?
Probably not.
Why did you put here in your report, there were no abnormalities noted on her exam if she had an elevated heart rate that it can be associated with a child in pain?
I don't know.
That is not a good enough answer. Oh, no, ma'am. And he doesn't follow up on this at all. What do you mean you don't know why you didn't include it in your report? That's called leaving out exculpatory evidence. This is terrible. This is terrible. She wrote a report about this report, but left out the fact that the kid is tachycardic. You can't fake that. And that is a good indication that she was in pain. This woman, where's the screaming goat? The screaming goat.
Okay. So if you've got, if she's tachycardic, if she has problems with her eyes from the light, if she has her knees flexed into the abdomen, if she has allodynia, meaning she doesn't want to be touched, and she has lesions, you've got 5 symptoms of RSD right there, do you not?
No.
What?
Okay. You're saying allodynia is not a symptom of RSD.
It is.
Okay, so
You're
there's
saying
one.
that, what do you call it when you're light sensitive? You're saying that's not a symptom of RSD?
No, I'm saying she was wearing eye covers. Was she photosensitive? I have no idea.
Okay.
Well, why was she wearing the sunglasses, ma'am? Why was she wearing them inside if she didn't have sensitivity to light and she was experiencing it because they told you that she was wearing them because of the sensitivity to light, but we don't believe her because we don't believe children. So there's 2 things, by the way, which are signs of RSD or CRPS, which she is blatantly just disregarding and saying, no, they're not.
She did not want to be touched.
That is correct.
That's a symptom.
So there's another one. That's 3.
RSD.
It could be.
All right.
Oh, there's another one.
It could be a behavioral manifestation.
Okay.
Oh, God, this woman.
And she had a fast heart rate, right, which supports being in pain, does it not?
It could.
Knees are flexed up into the abdomen. That can be.
Well, if it wasn't that she was in pain and she was tachycardic, then you should assume she has a heart problem. Chats are disappearing, Manders. Oh, listen, if you're watching the chat on YouTube, just know YouTube hides all kinds of stuff. And then I have to go in and approve it. And I don't have time for that. So if there are no mods in the chat, Flux is here though, isn't she? Flux, are you seeing chats pop up that need moderating? It's a thing that YouTube does. It's not, I didn't set it that way. So if anything's disappearing, it's because you've said something that triggered YouTube's automatic moderator. And without mods in the chat, there's no one to okay them.
An indication.
And I'm not monitoring the YouTube studio right now because if I open one more window on my computer, it's all over.
Right.
That's a positional description. I don't know what that has. I don't know if that has anything to do with CRPS criteria. It certainly isn't Budapest criteria, to my knowledge, that positioning yourself with knees up to the chest is confirmatory objective evidence.
All right, it might be happening. My computer might be shutting down. Everybody just hang in there. I'll be back. You can probably still hear me. So it's happening. It's happening. I hate this. I'm really getting tired of this. Send rants for computers. Super chats and rants for computers, folks. All right, I'm going to reboot. Did you do your squats? Did you do your squats while I was gone? Did anybody do the squats? You probably should have. You know what? Speaking of, we've been sitting around here for 2 hours. 2 hours is way too much time to not get up and move. So you know what we all need? We need a Nick Rekieta shaming right about now. You got a minute and 21 seconds to do squats, and then we're getting back to Dr. Sally Smith.
You impose fatness on you. You did it by going, oh, I want the butter on the popcorn. Oh, I want the butter on the ice cream. Oh, I want the butter on the sandwich. Oh, I want the butter on the salad. Stop eating butter. Can you just get up, walk 1 mile? Do squat! Walk farther. And if you can't walk, crawl, roll, get dragged by a goddamn forklift. Whatever is wrong with you, just move. Ever. Get off the chair. Get off the couch. No one is coming to service you while you sink into that furniture, while you become one with the pleather your poor ass got on that Walmart couch. Can you try not floating into sadness? Stop eating, stop drinking, start walking, start doing anything that you haven't been doing, you fat piece of shit.
Yeah, what he said. All right. I did all of the things I was supposed to do. Did you do that? I miss the 80s too. It's a good time. Jojo, thanks for the super chat. If I can pull it up here, it says $20 for a fan. I'm going to need more than a fan. I'm going to need like, I don't know, like a whole new computer, I think. You guys are so funny. While I was gone, your chats were so funny. Oh my gosh. Cue the awkward elevator music while I'm refreshing. Oh man. Your computer's ghetto. It's actually not. It's a MacBook Air Pro. I don't understand what's wrong with it. I really don't. I don't know what's wrong with it, but you guys are killing me. Oh, baby, come back. That's funny. We've got to have Rackets on the show again so he can do a live fat shaming while we squat. That will be fun. He's done that once before, and that was twice before. It was a lot of fun. All right. Marta, you're going to bed. We'll miss you. Good night. Sweet dreams. But we're going to keep going. We're in it to win it. And despite the computer problems. All right. Don't you feel better? Yeah, everybody feels better after some squats. I did some twisting too, because I need to get my spine moving. So I did some deep twisting, and that felt good. Taking 10 minutes to get my spandex on. Oh, man. Hey, Elsie Merritt, this is a very good point. The more I hear about CPS overly touching Maya, especially when she was in pain, the more convinced I am that CPS workers had the Munchausen's. This is not a bad theory. This is a good theory. This is a really good theory. Justin Smith said, let's diagnose Megan's PC for her. Oh, that's like a full-time job. I just need to go take it to the Apple store. And I'm lazy, so I didn't. So mean to make us do squats while drinking, but it's good for you. Mexican Vader says, I live to fat shame and be fat shamed. Yes, we all should. Be less fat. Are you still doing Vice's stream in the morning? Of course. Yes. Of course I am, because I'm a maniac. Of course I will. I'm going to be exhausted. I'm going to be in my jammies, but I will be there. All right, let's present this screen again. Embiggen, add to screen.
Hopkins All Children's Hospital. Is that true?
Let's back up.
At the time that I was
we
in the
don't need to
residency
back up.
program from July of 1984 until the end of December of 1985, it was just called All Children's Hospital. It was not affiliated with Johns Hopkins.
Okay. And in briefing, I believe there's also a claim that you took a faculty position at Johns Hopkins All Children's Hospital. Is that true?
No, again, I worked for All Children's Hospital, not affiliated with Johns Hopkins in any way, from 1990 until, from July of 1990 until, I believe, November of 2002.
Have you ever been employed by Johns Hopkins All Children's Hospital?
No.
Any claim to the contrary would be untrue?
Correct.
How does it work? It seems like from what you've testified previously that you were medical director of the Child Protected Team, but that you were both employed by Suncoast and Department of Health. Can you kind of explain that dual employment arrangement?
Yeah, so as the medical director of a child protection.
Danya figured it out. Danya Business figured out what's wrong with my computer. There is nothing wrong with Megan's computer. She is causing it to slow down because she has Munchausen syndrome by proxy and wants the attention that it brings. That's it. You got it. That's it. It must be that. Clearly, I'm causing it. I'm abusing my computer for the attention because I love attention. I have to have all the attention. So I'm clearly Munchausen. Yep. That's it. That's a good call.
Team, I received direct compensation from the Department of Health for some components of my responsibilities. Typically, that has been about 17 and a half hours per week for the last, I don't know, 10 or 15 years. The Suncoast Center Incorporated holds the contract for the Pinellas County Child Protection Team. I believe they have done so since 2008. And so in addition to the direct compensation that I get from the Department of Health, I also am in the role of the medical director for the Child Protection Team under Suncoast Center.
Whoa, she's double dipping.
Over the years, my
everywhere.
understanding.
So she's double dipping everywhere. I hope they ask her how much money she makes from each of these entities. So she's double dipping from the Department of Health and Human Services. She gets paid by them. She gets paid by Johns Hopkins. She gets paid by the Suncoast or whatever. I bet she makes bank. And what does she spend it on? Those ugly blouses. You know, Sally, people with money and taste don't buy terrible looking things like that. I know you have money, but yeah, I guess you just can't buy taste.
Is you've served on some committees with both All Children's Hospital and later Johns Hopkins All Children's Hospital. Is that correct?
Yes.
Okay. And pertaining to the times that Johns Hopkins All Children's Hospital strike that, were you ever compensated by Johns Hopkins All Children's Hospital for any committee service?
No. Back when I worked for the hospital, I mean, obviously I was participating in committees during time frame that I was, you know, an employee. But since November of 2002, I have not received any compensation of any sort for being on any committees.
Let me explain something to the chat because you guys are talking about privatization of CPS, blah, blah, blah. Folks, it doesn't matter whether it's privatized or not. It's funded by the state. It's not, when they say they privatize something, all they do is turn over the responsibility of the child welfare to another company, but the state still pays for it. And the state still has its dirty hands in it. Trust me when I tell you, it's not better either way. I don't know if it's worse if it's privatized or what, but it doesn't make any bit of difference. It's still corrupt. There's still tons of abuse, still tons of sex trafficking and all sorts of terrible things. The privatization versus non-privatization, there's not that big of a difference. The money is coming from the same place. It's not like when you privatize something, now that entity is like turning a profit. Like somehow they're just taking the money from the state to do the job that the state was supposed to do and just, shoved off on somebody else. It's not good. Privatized prisons are no good either. But either are state prisons. So you tell me what's the answer? I don't have a freaking clue. Anything the government is involved in, anything they touch is a disaster. And when they say they privatize a prison, well, it's not a completely private entity, right? It still has the oversight or whatever is coming from the government because that's where all the funds are coming from. So I don't know what the answer is. I do not know. But it's all bad.
So it's fair to say, since around approximately the turn of the millennia, you have not been employed by All Children's Hospital.
Not since November 2002.
This Fifth Avenue Pediatrics listed on your CV from March 2003 to the present. What is Fifth Avenue?
Strange how trials overlap, isn't it, Elsie Merritt? We had the witches coven in the Johnny Depp trial, and now we have a coven of witches in this trial as well. I agree with you that they do all kind of seem like a witches coven, like a bunch of, although at least in the Amber Heard case, they were attractive to look at. You could say they were more of the succubus variety. These ones, though, are like your garden variety witches with the bumps and the moles and the hair growing out of weird places. Chad Morrill, thanks for the super chat. Says, this doc reminds me of the older version of a girl I was interested in a few years ago. Voice, look, and all. If her character is the same too, she probably shouldn't work around kids. And it seems so. Chad, you need better discernment if you were attracted to a woman like this. There's something you need to work on within yourself. Yeah, the nose wart witches, the harpies. Thank you. These are not the succubus Hollywood sexy witches. No, these are the wart witches.
Pediatrics.
That's the current name for the private practice that I'm a partner in.
Is that private practice affiliated in any way with Johns Hopkins All Children's Hospital?
No.
My understanding is you were first contacted by a Johns Hopkins All Children's Hospital physician in this case on or about October 8 of 2016. Do you recall that conversation?
Generally, yes.
At the time that you were reached out to by Dr. Tepa Sanchez,
I love the word hag.
were you receiving that call as an independent medical staff position?
If I understand the terminology correctly, yes.
Okay. We want you to explain the difference between when you get involved in a case as a CPT versus if a doctor who needs a consult just contacts you.
Well,
yes.
Technically, the child protection team can be involved in a case if there is a report to the abuse hotline and either an investigator with child protective investigations or law enforcement requests for us to provide a medical evaluation. There are some cases over the many years I've been involved with All Children's and now Johns Hopkins All Children's, where that may or may not have occurred as yet, but a physician, knowing my expertise in child abuse pediatrics and my capacity as an active member of the medical staff, will contact me directly to ask questions about a case that they are seeing and seeking some guidance about.
All right. Crazy Warlock on Rumble. I resent this comment. Crazy Warlock says, I bet Megan is the type to talk into her mouse to try to get the computer to do what she wants. I'm not that bad at it. I mean, I'm pretty bad at it, but I'm not that level. But although I haven't tried it, if I talk into my mouth, stop overheating, bring me to the help desk. It's not working. I resent that comment. I'm not that bad.
Whether or not there may or may not be abuse or
Hello,
neglect
computer.
in the case.
Is there anything wrong or unethical about a physician who has suspicions reaching out to a child abuse pediatric such as yourself for some insight?
I can't imagine why there would be. For example, if somebody, if the doctor thinks that a child might have a heart problem, but they don't know exactly how to proceed with further pursuing that, they wouldn't be unethical to consult a cardiologist that's on the active medical staff for guidance. I think consulting an active medical staff member with expertise in child abuse pediatrics, in my view, would be the same thing.
Is it fair to say that when you were rendering services to in this case, that you were exercising your independent professional judgment?
Yes.
I guess my first question for you is, did you have a customary practice back in October 2016 and into 2017 as to how you would introduce yourself to a family where you're doing a CPT investigation?
Yes, I would state that I was Dr. Sally Smith and I'm a pediatrician with the child protection team.
Do you recall doing that with Beata Kowalski?
Yes, I've testified in depositions before that Mrs. Kowalski knew exactly who I was. The timing of the meeting with her, et cetera, was arranged a little bit ahead of time so that I knew she would be there and she knew I would be there. And I believe there were people from Protective Investigations that were present during the interview.
Do you actually recall introducing yourself as the medical director of the child protection team to Beata Kowalski?
Yes, I do.
Okay. And do you recall the same with respect to Jack Kowalski?
Yes.
You introduced yourself at that time as the medical director of the child protection team?
I may have introduced myself as a pediatrician with the child protection team. I don't know for sure that I said specifically medical director.
Sure. But you would have said something about your role with the child protection team?
Absolutely.
Earlier
I'm
this
sorry,
year.
but that does not mean that a parent is going to know that you don't work for the hospital or that you're DCF affiliated. Like, she's still going to think you're an employee of the hospital. And just saying you're with the child protection team is like, that's vague. Objection, vagueness. I just don't, I think it's vague. Now I would know what that meant because I have studied these people, but would anybody know what that means? Like, that's not introduced. Hi, I have the ability to take your kid away from you. That would be better. You know what? You know how they should have to introduce themselves? I got to get big for this. Hold on. I have to embiggen myself. This is how child abuse doctors ought to be required by law to introduce themselves to people. They should walk into the room and say, "Hi, my name is Dr. Sally Smith. You are under no obligation to answer me or talk to me. Anything you say can and will be held against you in a court of law. I am with the Child Protective Services team. I am contracted by the state to investigate child abuse. You have a right to an attorney. If you cannot afford an attorney, one will be provided to you. Do you understand these rights as I have read them to you?" That's how they should approach and introduce themselves to parents, because anything else is, well, the word just left my head, but anything else is like fraud. Yep, fraud. It's fraud. They need to introduce themselves by reading you your Miranda rights, because that is exactly what is happening. When a child abuse doctor walks into your life, you are under investigation and you should be notified of that fact. They should have to say, "I am a child abuse doctor. I am investigating you for child abuse. Anything you say to me can and will be used in court against you." There is no way that a person who works for the state, who has arrest powers, because she does, she has arrest powers, she has seizure powers. There is no way that a person who works for the state should be able, with that kind of power, to walk in and just say, "I'm Dr. Sally Smith, and I'm here to talk to you about your case." Meanwhile, knowing all the while, while she's talking to you, that she is gathering evidence to use against you in court. No, 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 no. Yeah, I mean, in this case, she was working for Johns Hopkins. She's on the payroll, but she's also contracted with the state. So they're the ones who blurred the lines. No prosecution without persecution. Yeah. It's not good what they did. It's not good. And things need to change. And one of the things that needs to change is that parents need their Miranda rights read to them when they're being investigated by child abuse agents. Oh, and you know what else? You know what else? They are not entitled to an attorney in family court. When you get your child taken away from you, you are not entitled to an attorney. And you damn well should be. The public defender's office ought to be responsible for defending parents against child abuse accusations, because nobody chose for these people to be in your life. They just show up out of nowhere. And you're supposed to now get $10,000 to $50,000 together to get a lawyer? And if you can't, you're screwed. And can I tell you, you're almost never afforded a lawyer in any of these cases.
Did you ever represent to Maya Kowalski that you worked for All Children's Hospital?
No.
Did you ever represent to Beata Kowalski that you worked for Johns Hopkins All Children's Hospital?
No.
Did you ever indicate to Jack Kowalski that you worked for Johns Hopkins All Children's Hospital?
No.
Did you ever prescribe medication for Maya Kowalski?
No.
Did you ever enter a progress note in Maya Kowalski's medical chart?
No.
Okay, to the best of your recollection, were you wearing a white lab coat with Johns Hopkins insignia on it when you met Maya Kowalski?
I don't have and have never had a lab coat with the Johns Hopkins insignia on it. I definitely wasn't wearing any such thing when I saw Maya Kowalski on either of the two occasions that I saw her.
Did you direct anybody with respect to Maya Kowalski's care and treatment at Johns Hopkins All Children's Hospital?
In the course of her hospital stay, there were times that I spoke with, I believe, Dr. Deese and Dr. Major with regard to the issue of medical child abuse and some things that could be considered in terms of
Chicago Jan.
demonstrations of
Welcome to the Fox
movements
Den.
that she was making that weren't consistent with the reported diagnosis of RDS, or what they're calling now complex regional pain syndrome. I had discussions with people about her course in the hospital, but I never was directing any treatment for her.
When you're working as the medical director of the child protection team for Pinellas County, is it common for you to discuss aspects of a patient with the patient's treating providers?
Yes.
And to your knowledge, did Johns Hopkins All Children's Hospital ever hold you out as Johns Hopkins employee or agent while you were rendering services as the medical director of the child protection team in Pinellas County?
No.
Okay. And at some point, I understand you talked to a Dr. Anthony Kirkpatrick. Do you recall doing that?
Yes.
What do you recall about the conversations you had with Dr. Kirkpatrick? Generally speaking.
So what I recall was that I think he called and left a message and I called him back, and the one thing I definitely remember was that he told me that I should not evaluate the child for Munchausen syndrome by proxy because that was not a problem in the case.
Okay. And did you consider his advice?
Well, I certainly heard him, but
No.
if I had heeded his
I already started.
recommendation, I would not have been doing my job. And
What do you mean by that?
well, my job in this case,
her job is to find child abuse, even if it doesn't exist,
was to respond to the requests from the investigators and law enforcement as to whether there was medical evidence of child abuse or neglect in the case. And the only way to do that when the concern is Munchausen syndrome by proxy or medical child abuse is to gather extensive medical records as much as one can, review all of those medical records, put that in the context of information that may be directly obtained, such as the information I got directly from.
Wait, you guys are killing me tonight. Irish Rover says, let's see. I was stirring the cauldron counterclockwise and I heard him, but I needed some gnat wings. So I don't remember what he said. Oh, this is a good one. Oh, I know this is hard to listen to. She is exhausting, and she's determined that she's right. She is right.
Beata obtained,
up a
such
little
as the in the context of information that may be directly obtained, such as the information I got directly from.
What was
Beata
that
may
word
be
salad?
all of those
Hold on.
extensive proxy or medical child abuse is to gather.
All right, wait. So when the concern, I'm reading the transcript because listening to her say this is, I can't even understand. When the concern is Munchausen syndrome by proxy or medical child abuse, her job is to gather extensive medical records as much as one can and review all of those medical records, put that into
extensive medical records as much as one can, review all of those medical records,
and put that into context of information that may be directly obtained.
Put that in the context of information that may be directly obtained, such as
the information I got directly from Beata. That was one sentence, you guys. That long ass word salad was one sentence. That the hell?
The information I got directly from Beata. Ordinarily, one would consider one's physical exam, but in this case, I was unable to conduct a physical exam on the child, and then put all that information together to try to determine whether there's medical evidence of child abuse. So if on October 11th or 12th, or 13th, when I spoke to Dr. Kirkpatrick, I had just said, oh, Dr. Kirkpatrick says there's no Munchausen syndrome by proxy here, so there must not be, I would not have been doing my job.
Do you know who Dr. James Lewis is?
Yes.
Who is he?
He's a neuropsychologist. At the time Maya was admitted to the hospital, he was a consulting neuropsychologist for the child protection team, and he provided a neuropsychological evaluation of her as part of the evaluation under the child protection team.
And he's not a medical doctor, is he?
No.
I believe he's a PhD.
Correct.
Is it common for people like Dr. Lewis to perform a psychological evaluation of a child who's the subject or whose parents are the subject of an ongoing investigation?
He was doing so probably about 20 or 25 times per year at that time.
Well, do you know who he was employed by back when he consulted with Maya Kowalski?
He was contracted with the child protection team, and so when he would provide a neuropsychological evaluation for a child who had been, referred to the team for assessment, I believe he would just submit a fee-for-service type invoice or something.
The chat's killing me. Hey, Pete, does this woman not know how microphones work? Why is she yelling into the mic like she's saying an eternal youth spell? She needs a young child to transfer their life force. Oh my goodness.
Something to Suncoast Center.
To your knowledge, was he employed by Johns Hopkins All Children's Hospital?
To my knowledge, he was not.
Other than the grand rounds that you've discussed, do you have any evidence that you received any compensation from Johns Hopkins All Children's Hospital?
I have not. Case.
Well, that you were well, you never even told her that you were investigating her for allegations
Here comes
that
Anderson.
she committed child abuse. Did you?
Did you?
Well, based
You
on
heard me.
Mr. Hughes's report of her email, I think we could, have a discussion of what she understood about what I was doing. But
No, this is about
I
you.
introduced myself as a pediatrician with the child protection team. I did not go into
Get her,
major
Anderson.
detail about what that meant.
Yeah, you didn't.
And you did not do that with Jack Kowalski, did you?
You didn't. You didn't. You didn't tell them. You made them believe that you were there to help their daughter. You didn't tell them you were investigating them for child abuse. You didn't do that. Get him, Anderson. Get him.
In
I
that
did
first
not go
interview
into
with him, let me finish my question. In that first interview with him, you did not tell him that you were investigating him for possible allegations under allegations of child abuse of Maya, did you?
I introduced myself as with the child protection team. I did not go into detail about what that meant.
And you did not tell Maya Kowalski in your version that you were investigating her parents for child abuse, did you?
I was taking a medical history from the people in terms of instructing them about that I was an investigator or something. I did not do that.
Just out of curiosity, what were you wearing when you interviewed the Kowalskis?
Business casual street.
What were you wearing? I don't know why that struck me as so funny, but incidentally, what were you wearing? Were you wearing a velvet cloak? What were you wearing?
Clothes and
a string of garlic around your neck? What were you wearing exactly?
ID badge.
Well,
Business
okay.
bitch.
And what does the ID badge say on it? Does it have your name?
Yes.
And it has Johns Hopkins on it.
It had a logo for the hospital as an ID badge would.
And what field of expertise did you hold at the time that Dr. Tepa Sanchez contacted you on October 8th?
Child abuse.
Chat's breaking me. What if anything? What if anything were you wearing when you destroyed this family's life? Oh God. She's wearing funeral attire to this deposition, so God, let's hope she wasn't wearing that awful Pride Parade blouse. What color is her eyeshadow? Grave dust. Oh man. Listen, if some of you are here who are normally in Lawn Lumber's chat, let me just explain something to you. We do mock people here. In case you're new and wondering what the hell is wrong with me. I'm not afraid to put up the hilarious comment. She parks her broom in the maintenance closet. Did you give the wand a whirl? Hail to the chat. You're on fire. I should go check Rumble. Because Rumble's got some good ones over there, too. Whoo. What are you guys doing over there on Rumble? I gotta go check on you. I shouldn't leave you alone for too long. Somebody knock her out of this locked track. What locked track? Oh, I think that was earlier. Did Rumble give up on me? Did you guys leave? The Rumble chat suddenly got quiet. Oh, love her moon shadow of Dash. Dash of mummy blush. I know. I asked him to come, but he was on his way to work. He said he's going to be listening, though. So, Legal Vices, if you're out there listening, the chat is missing you and your voices. There's a lawyer that does kind of sound like you're Rottenborn. Your Honor, I hate to inform the court. I can't do it. Ashes of poor souls. Now I have one of these scowl marks lines here. Wait, let me pull myself up large here. Oh, I guess you can't tell. Oh, well, StreamYard has this new thing that you can hit a button and it fixes your face. So I have a little bit of a like a filter on. So that's probably why you can't see it. But I have a frowning line right here on this side. It drives me crazy. And I almost wish I had a matching one because just having one is a little weird. So I guess I just frown with like half my eyes. Shelby says, I need a filter. Everyone needs a filter. StreamYard has a new feature that you can hit a button to I don't know what it's called. Wait, let me look at the settings. It says touch up my appearance. Yes, please. Yes, please. Okay, going back to where we were.
These pediatrics.
Okay, and you had active staff privileges on October 8th?
I did.
You had privileges at Johns Hopkins?
Yes.
Dr. Smith needs a filter. AP, my children would probably agree with this comment.
I'm so proud.
I'm so proud of myself.
Oh. You shouldn't be proud of yourself until you shave off Hair Island, sir. Maybe she has a witch filter. Is that it? Is Sally done? Is that it? Is she finished? Are we moving on to the next one? Her preferred drink is Malort. Why are they all laughing? Were they making the same jokes we were? Oh, man. Ashes Crazy Warlock says ashes of dead mothers and children's tears. Oh, that's sobering. Dang. God. This judge needs a hair filter. It's true. No, Rumble's still there. The chat's just slowed down. Oh my gosh. All right, let's see if we can fast forward through some of this. Obviously, we are not going to get very far.
Contacted.
Is it just the doctor, or are they going to be flashing up documents? Because I didn't watch the video. I didn't think that was necessary.
Wait, let's go back
to
what are we
video.
What are we arguing? I need to know. I'm nosy like that.
Okay, thank you. The jury's out of our presence. Everyone can be seated. Why don't we come back at 12:40, which is an hour and 15 minutes from now. That'll give us
Thanks, Tanya.
20 minutes to discuss whatever we need to discuss.
Judge, can I raise one quick issue, or do you have to go?
Hopefully it's quick.
Well, Judge, in reviewing the video for Dr. Newberger, I didn't actually watch the video. I just read what they said was on the video words. I'm not anticipating any exhibits coming up, and I just need to find out, are they going to be flashing pleadings or things during the video? Because I didn't watch it. I took their word that this was what was on the video.
And I saw that in Dr. Smith's, a couple of them, we did cover up whatever was being shown to her at the time. So.
One was a pleading, but in any event, that's my question. Is it just the doctor, or are they going to be flashing up documents? Because I didn't watch the video. I didn't think that was necessary.
I haven't had time to watch myself, but I'd suggest, is that solution acceptable?
Tanya, this is so true. The judge has his fuck around and find out radar on 10. He's so done with these people. He's like, listen, you clowns, get it together. Because I've had it up to here. I've had it up to Hair Island with you.
We cover things that come up on the screen momentarily. That box. Quicker.
Look, if there's going to be something that is not in evidence, it absolutely needs to be covered. Sure. Or somehow not shown to the jury.
I understand.
I've watched part of it and read the transcript.
I've just said what has to happen. I trust that directive is going to be taken care of.
Judge, as to the Sally Smith video at approximately 111 minutes.
For those of you not watching, you are going to want to know what I'm laughing about. Elsie Merritt says, I had a full head of hair at the beginning of this trial. This judge.
10 seconds, there was a response by Sally Smith where she said, and we had objected to this and she was responding to a law enforcement request that she conduct an investigation. So that is flat out true, and there's absolutely no evidence in this record that Dr. Smith was ever contacted and assigned.
Wait, did he just say
by
flat out
the-
true? Anderson, get your words together. You mean flat out false. If you're going to say there's no evidence that she was contacted by police, then don't say that that was flat out true. Look at the judge's face. He's thinking the same thing. The judge, Irish Rover says, I feel like the judge wants to pull the car over and just say, get out. Get out. Oh my God. All of these people in this courtroom are just insane.
Police department or the sheriff's department or anyone else. And so we would like an instruction that although the question and answer were allowed, there's no evidence in this record that Sally Smith was acting on behalf of the Sarasota County Sheriff's Department or anyone else.
Well, hold on a second. Wasn't the testimony if she get a referral from the hotline or law enforcement? I think was what it was an alternative. I don't recall her saying in this particular case that law enforcement requested her.
I will.
Jeff, you're here. The chat has been missing your voices. I wish you were here. This is crazy. This judge is so done. You missed an almost mistrial. You missed so much. I don't know if you've been watching, but and the witch. Oh God, the witch with the cauldron. You missed a lot of good stuff.
We'll double check the transcript. Maybe I heard incorrectly.
Let's
but
double check because I think there was an or, and I did not. Sitting here, I didn't get the perception that any law enforcement requested her.
We just want to make sure, of course, that the jury doesn't get the idea that she was under there for any particular tasking by the sheriff's department, the state attorney's office, or anything else. The only other thing at this point we wanted to just start out, we can talk about it later, is that
If we're going to talk about it later, let's not talk about it now.
What time do we need?
Not now, Anderson.
Let's be back at 12:40.
12:40.
All
Thank
right,
you.
so they're taking.
Thank you very much.
How much longer do we have? before
Now,
that? Let's see.
hold on a second. When I say
All right.
determine whether there's medical evidence of child abuse.
Let's back up a little.
anything else on that subject before we move on to the next subject,
No, Your Honor.
Mr. Altman, you stood up and walked this way. I didn't know if it was.
Wait.
I'd just like to ask that we hopefully have time at the end of today or first thing in the morning. We submitted our exhibit list for the day. We've withdrawn some of them. I've spoken to Ms. Crawls about it, and we'd like to get this done.
Well, let's first follow up on
Understood.
any motion, if any, that is coming from this morning's activities.
Yes, Your Honor. We went back and reviewed the testimony of Sally Smith that we directed the court to this morning, and there was concern on our part that the phrasing of
Time out. Are you moving for a mistrial or not? Let's deal with that issue first.
Well, the question that my appellate counsel asked is whether this court, upon moving for a mistrial, is open to a motion to defer ruling until the end of the case.
No, he said he wouldn't.
And as I told you earlier,
He already said he
I'm
wouldn't.
not inclined in making an advisory opinion on a hypothetical motion.
All right, at this time, then, we would not be able to move for a mistrial, although we think it's warranted
Oh my
To be
God.
clear, you are not moving for a mistrial.
at this point.
And are you seeking any type of relief, if any, at this point?
Sanctions.
We follow the court's initial thoughts on this, that any additional instruction in that regard would likely simply emphasize the testimony and cause additional harm. We do not believe that the harm can be cured by virtue of an instruction that the jury has now been well, I have to use the word tainted by the question and answer, which we found, given the court's repeated orders and instructions to counsel, completely inappropriate, and given the fact that it was given after several days, could not have been just simply an error on the fly. And so, but we do not think that a further curative instruction, we think it may do more harm than good.
Oh, Jeff, it's
but
crazy
if the
what
court
happened.
has an idea on that.
Jeff, I can't tell you. You're just going to have to go back and watch. And it is warranted. And I bet if he moved for a mistrial, it would be granted. But Anderson isn't moving for mistrial because they think they're winning, which after yesterday and today, I kind of agree. Although we don't know what the defense is going to pull out. And I know what they are going to pull out. And I'm still worried for the plaintiff because they are going to try and prove that Beata Kowalski was Munchausen syndrome by proxy. They are going to slander this dead woman's good name. That is what they are going to do. It's the only play they have. And I know they're going to do it based on Sally Smith's testimony that she was in a child abuser. That's what they're going to say. And it's going to disgust us. And I hope it disgusts the jury, but that's what they're going to do. And Jeff, if I could narrow it down for you, they were not allowed to mention the DCF case. And of course, that was all the defense. Like they can't talk about the DCF case. It's not relevant. And we're protected with immunity, blah, blah, blah. So what does Shapiro do? He gets up on the stand and then he gets one of the guardian ad litem on the stand. And one of the very first things he does is bring up the DCF case, and he prejudices the jury by telling them that the Kowalskis agreed with the shelter order. Now, of course, there was objections, and then the jury got kicked out, and then there was a big argument, and Shapiro was apologizing. It was a whole shit show. But you can't put that back in the bag. You can't tell the jury now, just ignore that you just heard that the Kowalskis didn't fight the shelter order. So they're going to take from that whatever inference they're going to take from it. Even if it was illegal, there was no explanation for it. It wasn't like, well, that's what their lawyer told them to do because that's how you have to deal with CPS. You have to do everything they say. And if you don't agree, well, then they make it worse for you. So basically, Jeff, that's what happened. They could have gotten a mistrial, but I think Anderson's like, oh, yeah, the silence of the judge. Jeff, you got to go back and watch it. It was great. But I don't think this judge is hard enough on what they did. I mean, I think he should have been I think the lawyer should have been sanctioned. I think he should have been held in contempt. And I think that he should have explained to the jury why they should disregard that and why it's irrelevant, because legal strategies demand that sometimes you go along with CPS. So that doesn't prove anything.
I operate based on someone filing a motion or orally moving. So I'm not hearing a motion. So
I don't think so, Judge. I think not at this point.
Okay. Anything else on that subject before we move on to the next subject?
No, Your Honor.
Mr. Altenberg, you stood up and walked this way. I didn't know if it was for this or for something else.
I think he was going to give it to him if he asked for it.
Okay.
Just seen this on a text message.
So let's move on to the next issue. So what's the next issue, Mr. Anderson?
During the course of the testimony of Sally Smith, we pointed out at approximately 111 minutes and 10 seconds, there was a question and response in which there was an objection by the plaintiffs, which the court overruled as to Sally Smith's response of her investigation being begun by law enforcement, and I believe the court said, thought it read, or state agency, and in fact it says and, leaving the impression within the jury, and I can read it into the record as necessary.
Mr. Anderson, do you mind telling us the date on the page?
Yeah, sure. It's
Sally Smith deposition from January 8th, 2022. January 18th. Sorry, January 18th, 2022 at page 111.
I believe in the
Thank you.
response here.
Oh, this is a very good question. What standard has to be met for a directed verdict? I don't know. I'm not the lawyer. This is why we need legal vices. I don't know what the standard is, but in my world, if I were the judge, I would not be limited to not considering that. I'll tell you that. I might just be tempted at that point after what Shapiro did to be like, you know what? We're moving for a directed verdict. Let's just do it. Let's just do it. I'm directing the verdict for the plaintiff. Now go figure out how much you owe. Because dang, That was bad what they did.
There it is. All right. And in context, it says, what
All
do
right,
you mean by
I'm being called out that I haven't mom shamed you yet for not hitting that like button. 269 live viewers on YouTube and only 157 likes. What do I mean? Nothing to you? Does this mean nothing to you? Are your thumbs broken? Did you do too many? You didn't do your chores today, probably. So you probably haven't even used your thumbs. Come on, hit the like button. You can do it. You can do it.
that? And it says, well, in order, my job in this case was to respond to the request from the investigators and law enforcement as to whether there was medical evidence of child abuse or neglect in this case. And the only way to do that when the concern is Munchausen by proxy or medical child abuse is to gather extensive medical records, such as one can review all of those medical records and put that in the context of information that may be directly obtained from such information as I got directly from Beata. Ordinarily, one would consider one's physical exam, but in this case, I was unable to conduct a physical exam on the child and then put all that information together to try to determine whether there's medical evidence of child abuse. And then, so if on October 11th, 12th, or 13th, I spoke to Dr. Kirkpatrick, if I had just said, oh, Dr. Kirkpatrick, there's no Munchausen by syndrome by proxy here, so there must not be, I would not be doing my job. We objected to that because in the context of the answer, it leaves the impression, the distinct impression by the jurors that Sally Smith's initiation of it, and particularly we're talking about October 8th, in the context of this, and the jury is well aware of our arguments as to October 8th, but that Sally Smith's initiation of her investigation was at the behest of law enforcement and investigators, investigators and law enforcement. And so if it was or, that might be a different story, but since it's and, we believe that a curative instruction is appropriate. We have one, if I could approach, and it's on the email, we can email that too.
I can put it on the screen. So you can put it on the screen, but hand me the sheet of paper. I just need the screen turned off.
Not very fancy, but.
Yeah, we all need to know
Okay,
how
I
many
see the,
doctors that we can legally shop.
Can you hand me the
Someone needs to tell us, what are the rules? How many doctors' opinions is too many doctors? Like, what's the cutoff? We need to know. So that if it's 3 doctors, we don't ask more than 3. If it's 4 doctors, not more than 5. How many doctors can you go to before you get in trouble? You know, there are no laws against doctor shopping. I really hate it when people say this too. It's like, do you know how hard it is to find a good doctor? Like, have you been doctor shopping recently? Have you tried to find a good one? Because it really sucks. So how many doctors can we go to and ask questions to and try to get help from before we're criminals? Could someone please write a law about it so that we don't have this problem anymore?
the run report or the deposition pages?
Here you go.
It's January.
It's at the bottom of the first page, Judge.
Oh, look at this curative instruction. Ooh. Ooh. During the course of the testimony of Sally Smith, she made a statement that implied that her investigation was instigated by Sarasota or other law enforcement or other agency. The court instructs you to disregard this question and answer. There is no evidence in this case that Sally Smith, MD, instigated her investigation at the request of law enforcement or state agency. Yeah, so she lied. I like what you say here, sweet one. Doctor shopping is the norm now. Can't just see one doctor. You have to see a specialist for everything. I have 5 and they have my medical number. They keep me busy. I think I bought their yacht. Probably. You probably did. All right, let's keep going. This is a good question. Would you lawyer shop till you found one that would win your case? And you find a doctor who can get to the root of the problem. It's the same thing.
What says the defense?
Well, first of all, I'm really not sure I see exactly where the confusion is. In order to do my job in this case, to respond to the request of the investigator and law enforcement, okay. So statutorily, when a hotline report comes in, it goes to both DCF and to normally the local sheriffs by statute. And she will get assigned by DCF. But law enforcement will also do its own investigation, which I presume is where this deputy came from in this case. So if law enforcement contacts her in its investigation as an agent of DCF, she probably does coordinate with them and can coordinate with them. Under 39-303 subpart 3, the CPT team has a lot of different things they can do. They can consult and provide advice to the doctors in this case, and the CPT team, they can do many other things. So I'm not so sure that this is saying anything that she doesn't do or isn't authorized to do. The instruction they have is saying that there's some implication here. I don't know that we need to give a curative instruction on an implication. And if we do, we ought to explain that she was appointed to do this on whatever day it was by DCF, and that Sunshine was doing this as an agent of DCF.
Well, I think the problem with that is, didn't she get called from the hospital ahead of time and started looking ahead of time before?
She got contacted by the hospital ahead of time. She did.
October 8th, and began reviewing that. And this, and if it hadn't said my job in this case, if she was talking generally, I would have agreed, and it said, or I agree with the court, you know. But in this case where she says it's my job in this case, and one of the key issues is when did she begin that job? Then it leaves the jury with the idea that everything Sally Smith did, even October 8th, was at the instigation of investigators and law enforcement. And if the jury believes that all these things she did were at the direction of law enforcement, which they directly were not, then that is extremely prejudicial. The jury will place, as we've seen time and time again, tremendous weight on the statements and actions of law enforcement. And we cannot have, from the plaintiff's point of view, and request the court's assistance, the jury believing that law enforcement in this early stage was involved. The facts are the only involvement came much later, and there was never an actual case filed by the state attorney. There was simply a detective, well, she was a detective briefly, who then questioned Jack Kowalski, and the court's familiar with those facts. But insofar as a formal investigation opened up by law enforcement, one detective does not make an investigation go. Regardless of those facts, the main problem is right now that jury thinks that law enforcement had given some right for Sally Smith, or more troublingly, had compelled or ordered Sally Smith to initiate an investigation. And that's tremendously harmful for us.
The issue is what she did on one day.
They should get the instruction.
Exact moment that she was assigned.
This
by
is the
DCF to
payback
do
for
that
what you did
investigation.
this morning.
The simplest thing would be to do her investigation. The DCF began specifically on that date. Now, I will tell you that the statute that gives the CPT authority to do things includes being able to consult and advise with doctors. And I don't read that necessarily as only after I have been assigned to do an investigation. Because, I mean, what she's explaining here is that people call her more or less to give advice as whether there's medical abuse so that they need to make a report. And so I don't know that from reading that statute that she's prohibited from giving advice in her capacity as the head of the CPT team as to whether or not a doctor's getting close enough to the mark that they need to turn in a formal report to do that. I think this instruction, as prepared at least, is much broader than it needs to be.
Well, how about something along these lines? During the course of the testimony of Sally Smith, MD, she made a statement that implied that her involvement was instigated by law enforcement. The court instructs you to disregard this question and answer. There is no evidence in this case that Sally Smith, MD, began her involvement at the request of law enforcement.
I have no objection to the
Here's my notes, so if anyone wants to look at it.
To the extent she's worried about implies that they lied.
Yeah, Judge, the issue I have with the instruction is that when you say she implied something, it makes it sound like she deliberately misled. And so my issue is with that language in the instruction. There's no indication that she was deliberately trying to mislead anybody with that answer. She gave a long answer to a question. And so that's my issue with this.
Because she probably did respond to questions from law enforcement, and that's quite likely to happen.
So can we just correct the fact without saying she, implied this, but it's
I'm
not
saying she lied, but she did lie.
May be construed.
Well, Judge, I don't think that it matters what her internal thoughts were at this time. The fact is the words that she said implied that. And I think the term implied is the best term for that situation. I don't think it should be watered down because I'm not worried about what's going on in Sally Smith's head here. I am worried about the implications of her actual statement on the jury.
Can we say just referenced during the course of the testimony of Sally Smith? She made a statement that referenced law enforcement. The court instructs you to disregard this. There's no evidence. That doesn't, because implied
Is what
implies
she did.
conscious attempt to mislead. That's my education with the
She
word
did
implied.
attempt
I
to
say
mislead.
Made a statement that implied. I didn't say Sally Smith implied. I said
No,
a
he just
statement
told
that
the
implied.
jury
And that's
she's
the
a fucking
point of this.
liar.
And I would move the court to enter it as the court had redrafted it the first time.
See, now if Jeff and I were writing these instructions, we would say, you are instructed to disregard what she said about law enforcement because she's a fucking liar. End of story.
What wording did you say?
I was going to say referenced, because you made a statement that referenced law enforcement, and then as you go on, you correct it. You say there is
Stick
no
to
evidence that
implied.
law
She
enforcement
did imply.
initiated the call, or however you have it on your statement.
Don't give up, Anderson.
I still do not believe that that will do
Good
the
for
job
you.
on something as powerful as this. If that jury comes away from this in any way thinking that law enforcement sent Sally Smith over there, that implies that law enforcement
Your Honor, I would like to weigh Sally Smith against a bucket of water.
already had sufficient reason to engage and send an investigator over. It imbues her with much greater power and authority, and it strikes the heart of whether the jury believes that all of this was warranted or unwarranted, and that is an issue in the case.
From a factual standpoint, and I'm correct on this, and I think both sides will agree, but if I'm not, Sally Smith's involvement in this case began when a doctor at Johns Hopkins All Children's Hospital called her up or texted her or contacted her. And so she went in and started it that way. It was not based on a call to the hotline. It was not based at the request of any law enforcement agency.
That's true.
Information about whether this was child abuse.
The judge isn't buying the defense.
This is at the core of this problem. There was, and we now have the specific times that were involved. And we know that the initial call was washed out at some point in the late evening of the 7th. And then we know that the next call for an investigation came in approximately 2 or 2:40. The time 2:40 p.m. comes to my mind on the 9th. During the 8th, there is no evidence whatsoever of any agency or any law enforcement or anyone in authority telling Sally Smith she should go do this. The evidence, overwhelming evidence, I think uncontradicted evidence, is that somebody at Johns Hopkins All Children's Hospital called her and asked her to start doing an investigation. And that is flat, plain wrong.
That's not true, Your Honor. The call was made by Dr. Baker Sanchez on the 8th. There was testimony as to why that call was made. Second call was accepted on October
Fat
9th.
Clark Kent.
Testimony that is at issue here was a follow-up question about a conversation that Sally Smith had with Dr. Patrick that absolutely took place well after the second hotline call was accepted.
Why is he speaking with his eyes closed?
So we're kind of negating some smoking mirrors here about that call in the 8th.
No, the point is that it was not accepted until, and if it's the 9th, fine. The point is, at the time she was doing all these investigations, she had no authority from the state to do so. There was no.
Folks. As a reminder, whoever speaks last doesn't win. That's not how I operate. I'm just rereading the question. I just want to be fair in this situation when it comes to what
God.
Dr. Smith actually said to the question.
I think I would hate being a judge because it would be exactly like what I do in my house all day long between the kids, like listening to them bring their stories and their complaints, and then I have to decide who's right. God, it's exhausting.
That was asked.
The judge is considering. He's speaking with his eyes closed because he's praying to Jesus to help him think of a way out of this situation.
No. Instead of using the word implied, I think I'm going to go with maybe construed.
Oh, that's a cop-out, Judge. Elsie Merritt says, why is he speaking with his eyes closed? Answer, the witches have written his script inside of his eyelids. He's going to go with the word construed. that construed that her investigation? That doesn't even make sense.
So during the course of Sally Smith, MD, or during the course of the testimony of Sally Smith, MD, she made a statement that may be construed that her involvement was instigated by law enforcement. The court instructs you to disregard this question and answer. There's no
Inferred
evidence
is
in this
better.
case that Sally Smith, MD, began her
Implied is
involvement
better.
at the request of law enforcement.
Agreed by the plaintiff.
Okay,
Construed doesn't sound right. It's the
so
wrong
I will give that
word.
as soon as the jury comes back in. Are there other issues we need to address?
For the record, Judge, we had moved to conform the pleadings to the proof insofar as the allegations of agency in our complaint. It is at paragraph 14, page 6 of the 8th amended complaint. Right now, their issue before the court is apparent agency, and based on the testimony of Sally Smith, which the party agreed, the defendant agreed to, a lot of evidence now has come in as to general agency based on the different committees she was on, her role there, and what she did in terms of the patient. And so what I want to be able to do is, I'm not sure if amendment to conform is the correct way or not. And I'm not sure, maybe it's relief from a prior order. But I want to preserve for the record the ability to request at the end a jury instruction on general agency as well as parent agency, because now, based on that testimony, the issue is much broader.
So I don't understand what you're asking me to do.
Well, I'm noting it for the record, and
can
so
lie
that's the first
is
thing. The court
better.
doesn't have to do anything right now. We would be filing a motion for the appropriate relief, but it's necessary for me to timely state that on the record, why we believed and what we intend to do that way.
Anybody on the defense
I
want
haven't
to?
seen a motion on this, but you already granted a summary judgment based on all of this stuff that was given to you once before and determined there was no agency. She's a member as a staff physician, not an employee, on a number of committees that the physicians are on to self-regulate them because they're self-regulated even when they're in the hospital. That doesn't make her an agent of the hospital. And he wants to put this evidence in to try to show it high, but we're going to have some instruction that we've already got into the.
Are they claiming she
proposal, at least
doesn't
explaining
work
what a
at
staff
the
attorney
hospital?
who has staff privilege, but a physician who has staff privileges as compared to an employee. So I don't think this changes anything. And we certainly weren't trying anything by consent by allowing this stuff to be plowed one more time.
Well, it doesn't sound like there's a motion in front of me to do anything at this point, so I'm not doing anything unless I get a motion.
Yes, sir.
Anything else before we bring the jury back in? Who's going to be reading Dr. Newberger?
I guess I'm Dr. Nick.
All right.
We were going to hire an actor.
So I'm going to stop this here. This is going to be the end of what we do for tonight because we're going on 3 hours, and now we have to watch Anderson at some point get up there and be Newberger, but we might have to watch that on our own because tonight I think this is it for me. It's been a lot of fun, and thank you for being here tonight. I'm glad we got such a nice size crowd. And so what's going on tomorrow? That's what we got to talk about. What's going on tomorrow? Tomorrow, I'm going to be on with Legal Vices in the morning, I think. He's doing the Melly trial, and I'm going to sit in for that as long as I can. I think Mr. Fox and I have to go to the bank or something, adulting that we have to do. So if I have to go and do that, then I'll come back and jump on wherever I can with Legal Vices, and then he's got his Friday thing. We might, if I have some time, I might come back and do part 2 of this tomorrow. But I got to sit on that Melly trial, you guys. It's so crazy. It's like the most terrible prosecutorial misconduct I've ever seen. Ever. And I guess Legal Vices tells me the prosecutor has been kicked off the case. So that's new news that I don't know about. And I can't wait to see this next hearing. I hope the judge is as pissed as I am. I doubt it, though. They never are. I don't know why our judges don't seem to get angry at the corruption of law. Robin, thanks for the super chat, says, "Hi Megan, I'm new to your channel. Glad to be here. I agree 100% about how any caseworker should introduce themselves. Liking your channel so far." Well, thank you so much. I appreciate that. Caseworkers who work for CPS really do have the power of arrest and seizure. And so, in my opinion, they need to come in announcing who they are, what their intentions are, and what your rights are. That would be a great law to put on the books, is that that caseworkers, CPS workers, when you're under investigation, they have to announce it and also read you your Miranda rights. Melly is a goat rodeo. That's funny. All right, let me check over on Rumble and see how everybody's going over there. Make sure there's no rants I missed. Rumble has been extremely stingy with the rants recently. So nope, there's none over there, but that's okay. YouTube did good tonight with the super chats. Thank you so much. I appreciate it. Atomic Ray says Johns Hopkins, all children's are bleeding sponsors and donors right now, as they should be, because, you know, they are getting some bad press. Hey guys, don't forget. Oh, McCrae, thanks for the super chat. Thanks for the stream, Megan. Looking forward to tomorrow. Tomorrow's going to be fun. Make sure, folks, that you go over to pjmedia.com and you clickety-click for me on the article that I wrote about this case. Now, it took me like 2 hours to write, 3 hours maybe? 3 hours to write this today. When I have to write something that's this detailed with court coverage, it takes for freaking ever. And I don't know why, but it just does. So do me the favor and go over and clickety-click on it. It helps me very much. The clicks help, the shares help. So if you could share that around, but also read it if you haven't already, because it went over all the good things that happened for the plaintiff yesterday. And so if you didn't see yesterday's stream and you didn't watch yesterday's trial, it's a good way to get caught up in a quick way, because it's just one 1,300-word article with some video clips that I edited together to edit in the best parts of the testimony. I'm going to try and continue doing that through the rest of this trial. I'm going to try and write companion articles to the streams that I do. I'll have to think about this one and what I can write about this one. Maybe the worst moments of Sally Smith's testimony. That means I have to do video editing. Oh, God. It's all right. I can do it. I can. All right, folks. It has been an evening, hasn't it? It's been a long day, a couple of streams today, and I'm ready to hit the hay. I'm going to bed. I hope that you guys have a really good night. Thanks for those of you who are new here, who tuned in just tonight. If you think you like this channel, then give it a subscribe and come back again. I would love to have you. And check me out on meganfox.locals.com. because we're doing a lot of really fun stuff over there. I do a lot of fun stuff like making cocktails, doing cooking streams, cleaning streams. We watch documentaries together, and we will be watching Take Care of Maya on Netflix together on my Locals exclusive. And that will be happening after the trial. I'm not doing it until the trial is over, because I just don't want all that information in front of me while we're still going through this. So that's going to be happening. So sign up and follow me on Locals for free. It is only $5 a month if you want to subscribe, and the promo code to get a discount right now is Maya, MAYA. You can use the promo code Maya on Locals, meganfox.locals.com. And also, I think that's for the monthly discount. If you want to sign up for a whole year, you can use the promo code SQUATS for a discount. Thanks to those of you who joined the membership on YouTube, the Fox Den tonight. And thank you for those of you on Rumble. I appreciate you guys. And I'll see you again, probably tomorrow. Tune in on Legal Vices. I'll be there in the morning.
Lost, my world is near its end. I almost felt my head is full of a million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh, this road has many choices. Oh, and my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye. Say goodbye. No, I don't wanna stay. No, I don't wanna say goodbye. Oh, alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh, this road has many choices, and my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye. I don't wanna say goodbye. No, I don't wanna stay. No, I don't wanna say goodbye.
So I take it that
Johnny's
you've seen
problem is he
Cameron
should have
John's
come
bedroom
storming
before.
in there with
Yeah.
a string of
Do you recall
garlic
what
and
he
some
went
holy
into,
water.
Mr. Judson,
And a cross,
towards
a crucifix
bedroom?
one.
May the
Do you
power of
recall,
Christ
or no,
compel you.
No, I don't.
You
sure
realized his house
misheard.
was infested with
Just up for
succubuses.
that,
and
there's a picture here with you of what it, yes. Do you recall what that was there when you arrived in the afternoon? I don't remember seeing it now. So how she?
No wonder he said drown her before you burn her.
Oh my God.
You-
Your next witness?
Now I know
Witness
why
for
you wanted to
Melanie
drown her.
Iglesias, and that
Next
is
witness
also
lives in
by
Romania.
video.
Is that correct?
That begins with Miss Vasquez.